ongoing.
Advice, Ms Crozier.
Ms Crozier?
So the government hasn't sought any advice as to how an election would be run with the impact of this, how this legislation would impact an election for campaigning or pre-poll activity.
Attorney?
Ms Crozier, no, we haven't sought advice on hypothetical situations. The advice that I've provided you is that nothing in this bill changes the Constitution in relation to the occurrence of the 2022 election.
Ms Crozier?
Thank you, Deputy President. Thank you, Attorney. Well, I understand the date is fixed and that is part of the constitutional requirement which you are referring to. But the activities around the election date for next November would be and could be impacted. And as you say, well, yes, it is a hypothetical, but it's an important element to understand because it's a possibility that it might occur because this legislation is coming in. There is pretty well, I don't think anyone's going to thinking that COVID will be gone by next year. We've seen the latest variant with Omicron and everybody getting their knickers in a knot over that. What's the next? There'll be another variant and another variant. And so what I'm trying to understand for the Victorian public is, you know, what provisions will the government put in place for campaigning activity or proper process to occur in the event that this legislation has to be enacted at the time close to the election?
Attorney?
Ms Crozier, I'm not in a position to predict what the pandemic or indeed what the concerns may even be in November next year. It's not relevant to the bill. There's no provisions in the bill that impact elections directly.
Ms Crozier?
Well, I think it does impact. I think it is relevant to the bill. I mean, this bill impacts what we can and cannot do. That's what this bill does. Correct. And the election of next year, which we were asked in the briefing and the advisors did not know. They had to seek that advice and the advice came back. But there are a whole range of aspects that will be implicated through this legislation for next year's election. How to vote cards, as I said, you know, on polling booths, pre-poll, campaigning activities that could be curtailed. So I think it is in the best interest for Victorians to understand this legislation could impact those activities. That is true, isn't it? This legislation could curtail those activities in the lead up to next year's election. Not the date. The date is set by the Constitution. But those important election activities could be impacted by this bill.
Attorney?
Ms Crozier, it might be something that we would get advice on closer to the event in the event that a pandemic declaration is in place. It's not open to me to go through hypothetical situations of next year's election. All I can confirm is that if there was orders that needed to be made for the protection of the Victorian public in or around November 2022, it would be done in accordance with public health advice and compatibility with the Charter of Human Rights and Responsibilities.
Ms Crozier?
Well, thank you, Acting President. And I raise the issue because I think it goes to the heart of our democracy and the issue around why people are very concerned about the powers of these bills and the erosion of our democratic rights. Now, you, the government, have had to amend this bill significantly based on the concerns and the fact that you didn't have the support of this House, of this chamber. So you've had to go out there and amend the substantial bill that was brought into the other chamber and again in this House amend it so you can pass it. So I think it is very relevant to what we are talking about here today, because the rights of Victorians have been eroded significantly, and they're not trusting of the government because of what has happened over the last 20 months. The lack of, as this bill will do, provide that advice. But I want to go to the point of the joint sittings, which is, well, we can, but I make the point because Attorney, and I know you're dismissing me here, but I think these are really important issues, because the joint sitting element under the current formation of how the parliament is, you've got a large majority in the lower house. You've seen where the crossbench have gone with your so-called closed behind doors negotiations. So the joint sitting, the power of the parliament means nothing. The joint sitting means nothing in this bill because it's so weak. You can't get the oversight that you are saying this bill will do. It actually doesn't give the parliament the oversight. And that, I think, is important in the context of how an election will be run next year. So I will ask more questions about the joint sitting element and the oversight when we get to the clause 12, I think it is. But I do want to stress that this needs to be considered very, very carefully. If you've got no advice to something that is so important to our democratic rights and our democratic principle about this very example of how this legislation may impact the state election next year, then frankly I don't think you've done a consultation broadly enough.
Sorry, Mr. Ballman, were you wanting to ask a question or just sitting down? No, sitting down. Mr. Bark.
Thank you very much, Deputy President. I might ask a question or two also about oversight, just picking up some of the points that Ms Crozier made. And in doing so, I'll refer to some of the criticism of the bill that's been made by the Victorian Bar Association. So certainly my view, in keeping with the comments of Ms Crozier and others on this side of the House, is that the oversight mechanisms in this bill don't go anywhere near far enough, and the Bar Association agrees. Now, in a statement released just recently today, the Bar Association said this regarding oversight. Firstly, parliamentary oversight. While the joint committee proposed by the government will be able to recommend disallowance motions for pandemic orders, these must be passed by an absolute majority in a joint sitting of Parliament, a point that Ms Crozier was referencing before. The government of the day, I continue to quote the Bar Association, will almost always hold this majority. The Victorian Bar believes the minister's pandemic orders must be subject to ordinary disallowance procedures applicable to the legislation. And so my simple question to the Attorney is, why does the government believe differently?
Attorney?
Thank you, Dr. Bark. With respect, the Bar are incorrect in their assertion there. If you look at the history of the makeup of this Parliament, including even recently, that is not what would eventuate. To suggest that there is every instance the government of the day would win a joint sitting by an absolute majority is factually the assertion that the government of the day would always win a absolute majority in a joint sitting is factually wrong, and history would demonstrate that it is not almost always correct either.
Mr. Bark?
Thank you, Deputy President. Continuing on the theme of oversight and scrutiny, and indeed continuing on regarding the deep concerns of the Bar Association. In addition, they say this: the proposed amendments replace detention review orders with detention appeals officers appointed by the Governor and Council and impose a requirement that they act independently. The Bar Association says, however, a detention appeals officer is appointed by the government. The Victorian Bar believes a review of the person's detention must be by an independent judge or magistrate. Again, my very straightforward to the attorney would be, why does the government believe differently?
With respect again to our friends at the bar, this is a nonsensical argument, Dr. Bark. As you would appreciate, as the Attorney-General, I make appointments of magistrates, Supreme Court judges, County Court judges and indeed VCAT members, and the exact same process will apply for the appointment of detention appeals officers. So to suggest that they're not independent would suggest that judges aren't either.
Mr Finn.
Thank you, Madam Deputy President. Minister, I go back to a question I asked earlier, and unfortunately you did give an answer, but it was probably a little irrelevant to the question that I asked, and that is the prospect of doctors being raided by authorised officers and confidential medical files being confiscated, as we've seen recently in Sunshine. What does this legislation do for the chances of that occurring again? How often, or should I say, does this legislation increase the Premier's power to authorise such raids?
Attorney?
Mr Finn, slightly convoluted question. The last part, no. Pretty clear, actually. The last part of your question, no. In relation to the construction of your other questioning, we went through the powers of the authorised officer in quite a bit of detail, and so my answer remains the same as what I gave you earlier, and there are avenues for people to make complaints if they believe that any actions of the authorised officers is not in accordance with the Act.
Mr Finn.
Attorney, it would have been nice to yes or no, but if you insist on that, we'll allow people to make their own judgment, I suppose. On another matter, and one that has been pursued a little bit tonight, but one that I have been, it's been suggested to me that I ask by a constituent, and that is, does this legislation in any way give the Premier or the Health Minister the power to stop unvaccinated people from voting at the next election?
No.
It's a big conspiracy.
Thank you, Deputy President. Attorney, in the second reading speech, the Minister commented and said the community leaders and experts that the government consulted with or took part in the process that were relying on information to suppress the virus. They also said that there were, in the second reading speech, the Minister says they also highlighted some problems that have emerged in implementing these measures. I'm wondering if you could provide to us what those problems were. It goes on to say they also raised concerns about aspects of the current legislative framework and difficulties in communicating the purpose and impact of these measures to the public. Now, I think this goes to the transparency issue, the lack of trust, the ability for people not to understand, but the Minister is saying that they highlighted the problems. I think we need to understand what those problems were.
Attorney?
Thank you, Deputy President. Ms Crozier, your question is outside the bill, but I would come back to my earlier comments that this bill has been crafted with the experiences of those that have operated under the existing framework to ensure that we have a more appropriate fit-for-purpose pandemic legislation framework for the benefit of Victorians.
Ms Crozier?
Thank you, Deputy President. Attorney, I fail to see how this is outside the scope of the bill when the second reading speech talks about the development of the bill, in which these paragraphs are under that subheading. This is about the bill, about the development of the bill. And I think that Victorians need to understand exactly those questions. So I put it to you again. What were those issues that were highlighted by the experts in the development, as pointed out by the Minister in his second reading speech?
Attorney?
I would point you to the details of the bill, Ms Crozier. Anything that is in the bill that doesn't currently exist is generally a result of the fact that the system under the state of emergency, under the Public Health and Wellbeing Act, was not fit for purpose, and that's why we have a bill that is aiming to do that.
Ms Crozier?
Well, I don't think that's a very satisfactory response, Minister. If you're going to just refuse to provide information to us, then it says so much about you and the government again. In fact, I would go to suggest that the response of the last 20 months has been so ineffective, so damaging, so destructive, that you've put this bill in place to cover up the mess that you have left here in Victoria. And No, well, if this state of emergency ends on the December the 15th, another state of emergency could be initiated. Could it not? Could it not? No, I'm asking the question. Could it not?
Sorry, through the chair, please. Sorry.
The state of emergency only exists if the Parliament approves the extension of it, Ms Crozier. Would you like to put on record your party's position in relation to that proposition?
Ms Crozier, just before I call you, can I just... Mr Finn, thank you. Can I just remind people once again, I know that there's a lot of emotion in this particular committee stage, but if we could refrain from commentary just being bantered across the chamber and come through the chair. If you wish to interrupt someone while they're on their feet, call a point of order, okay? Thank you. Ms Crozier, to continue.
Deputy Chair, I raise these questions because the government has said that with no framework in place post-December 15, come December 16, which is true. But it is also true that an extension of the state of emergency could apply where the current orders are in place. And that's what I was asking the Minister, because out there in the public, there are a lot of public that are confused about what is going on. So I was trying to get some clarity. And yes, to go to the Minister's somewhat, inappropriate response, we have said time and time again, bring it back into the Parliament so the Parliament can decide on a month-by-month basis. In fact, I brought in a private member's bill about greater transparency and accountability in the middle of this year, which you voted against. So it's not that we don't want greater transparency, what you are trying to achieve in this bill. What I'm trying to get to the bottom of is to explain and for Victorians to understand what this bill will mean, how it impacts them, how it was developed, and as has been highlighted in the Minister's second reading speech, there were problems that you have refused to answer or provide us with adequate answers on. So, again, I would say that the Minister's, in his second reading speech, did say that there were concerns around communicating the purpose and impact of these measures to the public. So how will you be communicating this legislation to the public and the impact that it will have?
Attorney.
Ms Crozier, the bill contains measures to do just that. It requires the government to table advice that it receives. It strengthens parliamentary oversight. There is the establishment of an independent pandemic management advisory committee with representation of a range of experts. And yes, appointed by the government, but by all means, if you've got people that you think should be on it, please make those suggestions. We want to have a panel of experts that the community have confidence in, people that are respected, people such as we've been discussing. I don't know if they've been offered positions, but you know, the likes of Professor Doyle, Professor Pfizer. These are people that really understand what we're talking about and bring expertise. So I take offence at your suggestion that the panel would be diminished in their expertise because they're appointed by the government. I extend the invitation for you to make suggestions of people that would be on that panel. In fact, I've received suggestions from members of the crossbench. This bill is about greater management of a pandemic, learning the lessons from the last 20 months, and indeed providing more oversight, more transparency to ensure that the Victorian public are very clear on why we are doing what we have to do to protect their interests.
Ms Crozier.
Well, thank you, Deputy President. Attorney, I wasn't diminishing their expertise, but I would say that well, I wasn't. You say this, I wasn't. What I was saying is it's a government-appointed panel that, with the history of what is shown, there is probably a fair bit of bias towards the government. But I have to say, if you look at the history of what you've got in your department, the advice that's been provided, well, I'm happy to say that we have not, the Victorian public have not got the transparency and accuracy of information that is being provided to you, but not to the public. Well, Attorney, I would say we've been in this House for 20 months arguing for greater transparency and the release of information, which you've never provided, ever provided. You provided. Yeah, it's not nonsense. Everybody knows that the orders are the orders. That is not the advice.
Sorry, Attorney, can we just let Ms Crozier finish?
If Ms Crozier could come to a question or at least advise the House that she's making a statement.
Well, no, I was going back to the
Ms
point
Crozier,
about, thank you, Deputy President. Again, you said that you had learned from the mistakes of the past 20 months. There are lots of mistakes. Lots of well, you said, well, correct me with what you said. You said we'd learn from the experience and the lessons of the last 20 months. So there are lots of lessons. You can't explain those to the House previously as stated. But I was going to ask, I'll come back to it actually because it's a later clause, but I wanted to just make the point. I know that Mr Limbrick wanted to follow up on one thing that I was saying, so I'll let him do it. But I do say again that it's important that the public understand how what you're saying in terms of the openness and transparency in this place will actually be afforded when there is a range of views that dispute that.
Ms Patton.
Thank you, Deputy President. And I just wanted to make a couple of comments, having listened for the last, getting on for 5 hours of this opening committee of the whole. And in March, I reluctantly supported the extension to the state of emergency, which many people in this chamber did not support. And they didn't support it for a range of reasons, and they fought vehemently against any extension to a state of emergency. And at that point, I made it very public that I was reluctant about the state of emergency because it lacked transparency, because it lacked accountability, because we weren't seeing, the advice, that we weren't seeing it coming back to the Parliament. So since March, we've actually been working on that. Since March, and I actually have to thank, and I'd like to thank Mr Davis for introducing me to the Centre for Public Integrity, because in March he did that. In March, he introduced me to the Centre of Public Integrity to tell me how wrong the state of emergency was and the reasons why it was wrong and the reasons why we needed pandemic-specific legislation, and the reasons were transparency, accountability and scrutiny. And I listened. And I listened to that, and in March I said to the government that I would support an extension on the provision that they introduce pandemic-specific legislation. And that's what we have before us now. And yes, it has been amended, and I'm very pleased it has, because even through that process of talking to Liberty Victoria, the Law Institute of Victoria, the Human Rights Legal Centre, the Centre for Public Integrity, while speaking to all of them about what this should look like. We were also looking at what Denmark was doing. We were looking at what New Zealand was doing. We were looking at what New South Wales was doing. What we knew that what we were doing in Victoria, which was very similar to what is being done in Tasmania, South Australia, Queensland, West Australia, Northern Territory, and probably the ACT and Queensland, was not what we needed for a pandemic where people were saying they didn't understand. They wanted to see that transparency. They wanted to effectively see how the sausage was made, why those orders were being made, on what was the advice. And here we have some legislation that is presenting that. And this legislation is better now because people have actually got up and done the work and worked and consulted with different organisations. And I don't think there's a single organisation out there that doesn't say that and I would actually challenge anyone in this chamber voting against this legislation to tell me that it's not better than the state of emergency. Tell me that this is not better, that this is not more transparent, that this is not allowing greater accountability, that this is not allowing greater scrutiny, because it is. And yes, you know, Mr Medic, Dr Ratnam, myself, we worked hard on this. You know, people can just stand on the sidelines and say no. And many people in this chamber have said, we don't care what this legislation looks like, we're not supporting it. And many of you are on the public record for saying just that. But in actual fact, I went out there and talked to the community. I went out there and talked to different organisations about what would make this better, what would be good pandemic legislation. And I'd have to say right now, we have got a whole range of amendments as a result of that. Now, many of you who will be voting against this legislation today, and you've made that very clear in the media, you've made it very clear that this legislation is something that we should be frightened of. And I ask you, should we be more frightened of this legislation than we were of the state of emergency? Because we were supposed to be very frightened of that because the minister wasn't responsible, because the health advice wasn't being published, because there was no oversight committee in the parliament, because there was no expert advice, because the ombudsman didn't have the right role. So we've listened to that, and I have carefully listened to the Law Institute of Victoria, to the Human Rights Legal Centre, to the Centre of Public Integrity. And I have met with them many times, numerous times, over this last, actually 6 months that I have been interested in this. And I you know, from the outset, when this legislation was first tabled and we saw it, we immediately sent that out, asked for advice, went to our stakeholders, got that advice, and still, I just don't know what the people who are voting against this legislation want. You know, this is something that is quite outstanding. This is something that is actually quite unique to Australia, in the fact that this will be the only state that is publishing its health advice. Only state that is publishing its health advice. Only state that it has. Only state that has. Ms.
Patton, sorry. Ms. Patton. When have we ever done that? Mr. Bark, sorry. Ms. Teeny on a point of order.
Deputy President, it is my understanding that you have made a number of comments in terms of the conduct of this chamber since we've started this, and a lot of them have got to do with unruly behaviour and interjections. I put to you that what has just happened with Ms Patton is absolutely unacceptable, and I ask you to pull those opposite into order.
Order. It's not a point of order, but Ms Patton, to continue without assistance, please.
Thank you. So now we have a series of amendments before us this evening that have been negotiated by a range of people and are as a result of the very good and diligent work of stakeholders, the very good and diligent work of the Ombudsman, the very good and diligent work of the Law Institute, the very good and diligent work, as I say, of the Public Centre, of the Centre for Public Integrity. all of that work. We have seen, we are now seeing a changed threshold for declaring a pandemic, reduced financial penalties, tighter publishing and tabling timeframes, clear application to our Charter of Human Rights, an independent advisory committee that is resourced, an entirely independent review of this legislation commencing within 18 months, a new parliamentary joint committee without a government majority to oversight it, a new mechanism for parliamentary disallowance, an independent detention appeal panel to sit outside of health and be appointed like a commission, clarification of just how the Ombudsman can review these matters, an entrenched right to protest, plus undertakings in relation to detention guidelines. This is supported by the AMA, by the nurses, by, as I say, all of those legal entities and stakeholders, and still it's not enough. And I would love, in the 5 hours, I have not heard anyone articulate what they want. All you want is to say no. And that's easy. It's really easy to say no. It's actually a lot harder to come to the table, to pick up the phone and to work on it. Thank you.
Attorney.
Thank you, Ms. Patton, and like other members of this place in the last 5 hours have taken the opportunity to make statements, and thank you for your insight. It's really considered, and appreciate the effort that you have gone to give due consideration to this bill, and we welcome your support, and we know that we haven't met everything that you wanted addressed in the bill, but we have gone a long way to meet those. But there was one of the comments that you made that I just wanted to bring to the attention of the House. You mentioned the Centre for Public Integrity, and you mentioned that they were brought to your attention by Mr. Davis. As we know, we've engaged with a lot of stakeholders about this bill, and it's often, don't take my word for it. It's good for me to be able to point to experts and their opinions of this bill, because I think that that's more powerful than me as a member of the government trying to persuade you that this bill should be voted on tonight. But I do want to put some comments on the record from the Centre for Public Integrity. The amendments that have been conceded by the government in the last 2 rounds of negotiations provide a far better framework in which the need for extraordinary, urgent government action to keep the community safe is met, with a number of extraordinary, fit-for-purpose, transparency, oversight and accountability mechanisms that are consistent with Victoria's democratic commitments. We think the proposed legislation is standard-setting. In the circumstances, what has been achieved is laudable, and there are many dimensions of the legislation we think will be or should be adopted in other jurisdictions in Australia and abroad. And of course, and I guess to some of the points that we were referring to, Ms. Crozier, of course there is the fact that we are still learning about pandemic management.
Ms. Bath.
Minister, I hobbled. Minister, Attorney, in terms of the panel, I've been listening, I was here for most of the time except for probably half an hour. I would like to understand about the makeup of the panel, and what we've seen is with any major emergency, we've seen the importance of complete management, and by that I mean logistics, people who can effectively organise and manage an emergency. So I want to understand on this panel, as well as health advice, are there logistical people? Are there people who can rally an army, for want of a better word, to be able to organise a pandemic, or is it just constituted with health experts?
Attorney.
Thank you for your question, Ms. Bath. The panel would be a range of experts who can provide detailed information that would be pertinent to the orders and the particulars of the pandemic. For instance, if it was a new pandemic that only impacted children, you would have paediatric experts. In relation to, I think we have had a lot of question around would a business community be invited to participate? We are not limiting the expertise of the panel. We want it to be flexible, appropriate, and to ensure that we can receive advice from a range of experts relevant to the particular circumstances.
Ms Bath.
Thanks, Deputy President, and thank you. And again, I guess I go to the point where when you have these significant reach of restrictions that can be placed on people's lives, there needs to be, again, significant understanding of the ramifications. So small business, yes, industry, yes, but also the logistics of how to keep a supply line going, how to not grind the economy down to a standstill that we've seen. So, Minister, how would you assess the best panel for there to be, to have logistical experts, to have supply chain experts, to have the army if we need to have all of those sorts of broad-reaching and matrix of good skills?
Attorney?
Thank you, Deputy President. As I said, whatever expertise based on the nature of the pandemic would be relevant to the panel at any particular time.
Ms Bath.
And who makes that decision? The Premier and the Health Minister, Attorney?
Attorney?
The Minister for Health, in consultation with the CHO, appoints the panel members.
Mr Limbury.
Thank you, Deputy President. Oh, no. This one, sorry. Thank you, Deputy President. I'd just like to briefly respond to Ms Patton's remarks about what do people who oppose this want. I can't speak for the Liberal Party, but I can certainly speak for the Liberal Democrats. We have openly discussed that we are happy to have some sort of quarantine and detention powers for people who are infected. But what we don't want is the government to have the power to have a two-tiered society where people are excluded from society. We don't want the government to have the power to force businesses to sack people based on their medical status. We don't want the government to have the power to lock people in their homes for months on end. And we don't want the government to suppress protests and open fire on people. This is what we've seen over the last 20 months, and this is what we don't want. So I think that the idea that, you know, we're somehow just opposing everything that the government does and not being constructive at all is totally wrong. But that said, I would like to ask a question with regards to human rights. Again, one of the key principles, which was incorporated in the Public Health and Wellbeing Act, was around time limited, right? If there is going to be a restriction on rights, then it must be necessary, proportionate, justifiable and time-bound. Why was the decision made in this legislation so that there are no time boundaries on orders that are made? So, like, because we can keep continuing this forever. In the previous legislation, there was a time boundary of 6 months, which could then be extended later, but there's no time boundaries in this. How can this be considered a justifiable way of managing human rights when there's no time boundaries on it? And why wasn't it considered that, you know, we had, say, 3-month intervals? Or I know that the government has criticised some of the opposition's amendments in the past when they said, oh, well, you know, they wanted month-by-month extensions, which we actually supported. You know, and I think the government's response was, oh, it might be a waste of Parliament time. But, you know, we're talking about suppressing the rights of Victorians here, and I think that's an absolutely appropriate and very important thing for Parliament to be debating. And we've seen the level of public engagement with this debate at the moment because they know that their rights are at stake here. That's why so many people have been upset. You know, why wasn't some sort of 3-month or 6-month or whatever it might be, some sort of time boundary decided on rather than this endless pandemic power?
Attorney?
Thank you, Deputy President. Mr Limbrick, unfortunately there is not a expiry date on a pandemic. It is essential for the government to have flexibility and confidence to manage and respond to any emergency circumstances causing serious risk to public health or a significant and widespread danger to life or property in Victoria. The current pandemic has been present, as we know, for almost 2 years, illustrating that it is extremely difficult to anticipate how long a pandemic will pose a serious risk to public health, and it's impractical to place limits on the number of renewals of a pandemic declaration, as we have lived through the extension of the state of emergency situation. The government's pandemic management bill proposes far more responsible and balanced course. It contains numerous checks and balances, as we have gone through many of those measures throughout the committee stage today. Extensions on the pandemic declaration are limited. They are limited to 28 days in the first instance and then 3 months afterwards. And as facilitated by the amendments, the government has agreed to commence a review of the new part of the Act within 18 months.
Thank you. And just before we continue, I just might clarify something. Just with Ms Patton's comments, and thank you, Ms Limbrick, for clarifying your position on it, but Ms Patton's comments tended to try and open this up to be another second reading debate, and this is not a time for speeches about what people want or don't want in a bill. We are in the committee stage. I remind everybody the committee stage is about asking detailed questions about the bill. The time to put on the record what you want in the committee stage is as part of your amendments, and you will speak to your amendments, and that is where we will hear what the crossbench and the opposition want out of this bill in this stage. The time for general commentary around what people wanted or didn't like about the bill was the second reading speech. So, yes, Mr Limbrick.
Thank you, Deputy President, and I appreciate that clarification. I didn't intend to make a statement, but I felt compelled to respond because it was clearly directed at people who are...
I wasn't criticising you. I was just saying that Ms Patton's comments were wrong because it tended to open it up to that, and I was just making that point, that it's not about a time for people just to make speeches about what they wish to be in the bill. That is part of your amendments in this part of this, or this stage, in the committee stage, and you're quite within your rights just to continue to ask detailed questions about the clauses in the bill, which is what this stage is about.
Thank you, Deputy President. Again, I'd ask the attorney on the time limiting part. Like, I don't accept that the 28-day limit is valid because, it's valid, but there's no. If the ideal or the objective of the bill is to increase parliamentary oversight, for example, why was the decision made to not have some sort of parliamentary oversight at regular intervals, so like 3 months, for example?
Mr Limbrick, the new joint committee will not be confined by any time limits. They can inquire into any matter within the scope of their remit, which will be established through this bill, and there's no requirement for them to sit when Parliament's sitting or anything. They can have full oversight at any time.
Dr Cumming.
Thank you, Deputy President. And my first question to the attorney is around something that Ms Patton raised around, what other members of Parliament want. Does the government regret actually not including all members of Parliament in the conversations, in the discussions from March this year? Seeing that, for myself, as soon as I was able to see a copy of the actual bill, I was able to read it and make amendments that I could debate. It would seem that, listening to Ms Patton, she is unaware of the amendments that have been made. And for myself, Ms Patton just earlier asked for a copy of my amendments, even though I brought the amendments 2 weeks ago into Parliament. I've sent emails, I've You know, I've had those conversations. I guess, Attorney, this is one of the problems I've sensed from having individual conversations with members of Parliament rather than having us all in the room to be able to hear each other's concerns, build on each other's concerns, you know, make improvements to the bill. So my question is, does the government regret not having these conversations with members of Parliament earlier?
Attorney.
Thank you, Deputy President. Dr Cumming, whilst not directly relevant to the bill, I appreciate the considered approach you've taken to your contribution to this legislation. I went through the experience in the last couple of weeks and the short time frame the government had to construct this bill. 6 months, 9 months, it's not a long time to draft a bill. That's very quick, particularly to craft a bill that is to respond to such important urgent matters. So it's fair to say that a lot of the issues were not issues until the bill was made available, and as we've seen in the last since the bill has been made available, a series of amendments have been agreed to, and I thank those that have contributed to that constructive dialogue to formulate what is, if you take the stakeholders' word for it, a very good bill that deserves to pass the Parliament of Victoria.
Dr Cumming.
I guess, Attorney, we've had this debate before when we debated the state of emergency last September, and when the government wanted, because this pandemic bill is just amendments to the Health and Wellbeing Act, and previously when we did the state of emergency, the government, or the Ombudsman bill and the state of emergency last September, there were issues that I raised at that time around that the authorised officers were in the bill already. There were things that actually sat under local government within the Health and Wellbeing Act. And even at that time last September, that's 12 months ago, that it would have been great to start having those conversations with the government from the experience that I have in local government, knowing that local government is an arm of the state and that a lot of things that this government has done throughout this pandemic, if they had used their arm, which is local government, there could have been other amendments made to the Health and Wellbeing Act in shorter time frames than these 12 months that would have helped along the way. If there was consideration at those times, because it was very quick for the government to be able to attach hotel quarantine and the cost at that particular time. That amendment to the Health and Wellbeing Act was snapped together quite quickly. So it shows to me that when the government is willing and wanting to put up amendments in a quick time frame, they can. But I feel, and you can tell me if I'm wrong, that because we were sitting under a state of emergency, that these amendments took the time that they did, because you were just waiting for the end of this state of emergency rather than doing the amendments that needed to be made at the times that they could have been made.
Attorney.
Thank you, Deputy President. Dr Cummings, I can confirm that the MAV were involved in consultation in development of this bill, and I'm sure that experiences from local councils were fed into the development of this bill in relation to the experiences that people had that was considered by the expert panel and indeed the Health Minister before he brought this bill to Cabinet.
Mr Limbrick.
Thank you, Deputy President. I'd just like to clarify something that the Attorney mentioned earlier about when the drafting of this legislation started. Can I just clarify, did the Attorney say it started drafting in March this year?
Attorney?
No, I think March was when we committed to developing a standalone pandemic-specific legislation. I don't know when the drafting started. Ordinarily, you would develop submissions and consult, drafting instructions before drafting starts, so I don't know when the actual drafters commenced this bill, but it was the debate, and I looked back at my Hansard for the extension of the state of emergency, where I put on public record that it would be the government's intention to start the development of pandemic-specific legislation.
Ms Barr.
If you want to go. Finish off? No, thank you. Thanks, Deputy President. Deputy Attorney, I'd like to talk about, in the Health and Wellbeing Act under the emergency powers, there's a compensation clause, and it says a person who suffers a loss as a result of a decision by the CHO to give authorisation and they suffer a loss, they can apply to the Secretary for compensation. Now, I'm interested to understand how this new bill will influence that. Will somebody who's been aggrieved, and we know that throughout the pandemic there has been a great number of people who have suffered a great deal of loss, and often at the hands of whether they be fines for not following, not having the right sign up in their front window, or not having the hand sanitizer or something. There's some fairly significant fines that have been measured out. So I'm interested to know, will that be captured in this bill? Will it still be the Secretary, or is it now the Health Minister and the Premier that will affect this clause in terms of compensation?
Attorney?
Which section of the Substantive Act are you referring to?
Yes, it's page 194. Thanks, Attorney. And it's Division 3, Emergency Powers. Yes, 204.
My advice is that that doesn't apply under this bill.
Ms Barr?
Thanks, Deputy President. Could you elaborate as to why that doesn't apply under this bill? What's not being caught by this? Could you elaborate on your answer, please?
Attorney?
I can confirm that this provision has never been used, and so there was no intention to transfer it into the bill that we have before us today.
Ms Barr?
Deputy President, it's never been used, but having said that, you won't be able to enact or seek compensation with this new legislation, even though you could have been severely affected, locked down, and as this said, suffering loss as a result of the decisions now by the Health Minister or the Premier. So you're not allowed to seek compensation.
Nothing in this bill prevents people's rights from accessing consideration from the courts, but this is a very limited provision that, as I said, has not been utilised. But in relation to people that have certain issues that they wish to take to the court in relation to similar to the matters that you've raised, that is certainly still open to people.
Did you have another one? No. Mr Rich Phillips.
Thank you, Deputy President. Attorney, I'd like to take you back to a couple of matters that were raised by Dr Bark a little earlier in the committee's consideration of the bill. The first I'll take you to is the matter of disallowance of orders and the mechanism.
to other members that specific questions around that are best left to the clause. And I guess I would also ask members in terms of general questions, would you like to move through clauses so that you can ask these specific questions? Or did you still have matters in clause 1 that you wanted to go over? Because if we start to get into the specifics, I'd prefer to go clause by clause. It's easier to follow.
Okay, Mr. Finn.
Thank you, Madam Deputy President. I want to go back to an issue that I raised a little bit earlier, and I just want to clarify with the attorney, if indeed she did make an offer to those unvaccinated Victorians who cannot get an exemption from the committee that she has asked them to apply to. I understand, if my recollection is correct, that she offered to some assistance to them. If that's the case, I'm very, very pleased. But I just wish the attorney to clarify if indeed that is the case. For example, my sister has told me, and I've been contacted by a number of people listening to this debate, watching this debate tonight, that they have been to their doctors, and their doctor has said, don't worry, don't bother even trying because you're not going to get an exemption. It doesn't matter what's wrong, you're not going to get an exemption. Now, you know, this is happening all over the place. People are going to die because of this, and that's something, you can't get much more serious than that. So I'm hoping that the attorney will clarify that she is in a position to assist those Victorians who wish to make an application for exemption of this nature.
Mr. Finn, whilst not directly relevant to the bill, whilst your question is not directly related to the bill, as I did indicate to you, the Minister for Health's office would be more than happy to provide advice on the process for those people that wish to seek more advice in relation to exemptions. I outlined that there is VIXIS, who you can ask for further advice on exemptions. I explained that ATAGI are responsible for detailing where those exemptions apply, but absolutely, if you have your sister or anybody else would like to send through their details to the Minister for Health's office, information will be provided.
Mr. Finn.
Alternatively, we could go to the funeral. Attorney, on another matter, you said before, gave a guarantee before, that this legislation would not prevent people voting at the next election. Given the Premier's enthusiasm for segregating the vaccinated from the unvaccinated, would this legislation prevent the unvaccinated from actually physically attending a polling booth with vaccinated people? The same polling booth.
Attorney.
This legislation states that, no.
Mr. Finn.
Thank you, Madam Deputy President. I'm very interested to know what is so special about voting, given that you can't be an unvaccinated person at a pub with being with vaccinated people. You can't be an unvaccinated person at a whole cinema and a whole range of places. But apparently, it's all right to go to a polling booth. I'm just wondering what the special significance, the magic that a polling booth holds that protects people from the dangers of the unclean.
Attorney.
Mr. Finn, none of the examples that you just articulated are covered in the bill.
Mr. Finn.
That's why I'm asking the question, because I want to know if indeed this legislation gives the Premier the power to stop this. Now we have here and I know we're jumping ahead a little bit, but later in the bill the note refers to the Minister may make a pandemic order that the Minister believes is reasonably necessary to protect public health. Now, I would assume that given what has happened in so many instances already with regard to the segregation that has been put in place by the Premier, that the unvaccinated would not be allowed to attend the same polling booth as vaccinated people. That would be, to my way of thinking, a natural follow-on position, given what has already happened in this state to this point.
Okay. The Attorney will take that as a statement. Dr. Cummings.
Hallelujah. Thank you, Deputy President. And I'm almost, an Attorney apologise, but I'm almost going to take an interjection off the floor from Mr. Lean. And it's a question. And the last time we met, and it was at the end of that week, that's when the Premier actually announced that on that Thursday night that 12, 13, 14 and 15-year-olds have to be vaccinated to be partaking in everything but school. And they have to be double vaccinated, and that's what...
And the supermarket.
And a supermarket everywhere. So for myself, I've got a 10 and 12-year-old, and in this chamber I brought up to the Parliament's attention that my son, would have been struggling to go to his 10-year-old's brother's birthday on Saturday. So Mr. Lean, during that week, I went and saw my GP. He's been in Footscray for 50 years to talk through the possibility of getting an exemption for my 12-year-old. My family has a history of heart disease. My father died at 54. My nephew died last year, Mr. Lean, at 39. And I would like to check out my 2 young boys' hearts before I go down the path of giving them a vaccine. That I know that currently in the hospitals there are 50 children, teenagers, presenting every week with heart conditions from reactions from these vaccines. So for myself, I wanted to check that out, and I wanted to be able to get an exemption while I went and saw a paediatrician. My doctor of 50 years of experience said to me the only exemption can be given is if he's allergic to the vaccine. So for myself, Mr. Lean, and others, and the Attorney, it is very hard to get an exemption. Even when you actually have deep concerns, family issues, things that anaphylaxis, diabetes, you name the condition, because there are no such thing as an exemption to the vaccine, only if you're allergic to the vaccine. And you can roll your eyes at the moment, Mr. Lean, but I can assure you that's what the GPs and others are being told. And I hear from the Attorney that there is a long list of possible exemptions, but they are not being used. And when I said to my GP that I'm the mummy, I'm the parent, Mr. Lean, my son is under 16 and I should be able to make those choices for my son. He doesn't understand fertility. He doesn't understand if he's got a heart problem or not. And for myself, my parental right is being taken away because of this mandate, right? And you're going to continue this mandate up until 5. Not recommending, but
Dr.
mandating.
Cummings,
So my question is this. What is the exemption, Attorney? Because I cannot, please read out the exemptions, because nobody seems to, because it's not happening at the moment. Not even the time, recommending, it's mandated for 12, 13, 14 and 15-year-olds who do not have the mental capacity to understand why they can't go to their formal at the end of the year because of not being double vaccinated.
Attorney?
Thank you, Deputy President. Dr Cummings, I would refer back to my previous comments in relation to exemptions to vaccination. I'm not in a position to provide you with detail through this committee stage. I'm not a health expert. I've also offered for you to accept a briefing with Professor Doyle, and as I've indicated, I will be able to perhaps assist by providing you with the published lists of contraindicators published by ATAHI in terms of the exemptions. So it's not I understand the issues that you're raising outside the bill, but I'm happy to facilitate further information for you and indeed for you to have a conversation about these issues with relevant experts separate to the bill.
Dr. Cumming?
Thank you, Deputy President. Thank you, Attorney, for your answer. But it's not helping the community at the moment, because we're in a situation where we've got 12, 13, 14 and 15-year-olds who can't access their Medicare records because you have to be 14 and above. 12-year-olds cannot make those decisions. It's their parent. And my GP said all of his job is for willing parents to put the vaccine into people. But if you've got concerns, you wish to get an exemption, you wish to go down a path of finding out if it's okay, he cannot do. He cannot give me an exemption for 3 months while I wait for the paediatrician. And to get a paediatrician's appointment is 6 months. To go see if my child has either behavioural issues or has mental health issues due to the lockdowns, it's very hard to actually see a mental physician at this time. So for myself, what I understand also, and this is my other question, Attorney, while I'm still on my feet, there are many people out there that have already had COVID and they wish to have an exemption because they've already had the disease and they've got an immune, or they've got a natural immune or herd immunity, and they are being denied an exemption. They are being told that they have to vaccinate. There are many people out there currently who have had 1 dose of the vaccine, they've had a reaction and they're being told to get the other dose. Now, I know it's GP by doctor, but it's because of these mandates that the GPs, the physicians, the specialists are not seeing people because they're not double vaccinated, Mr. Lean. I mean, that's ludicrous. No, you're sitting there mumbling, so if you want to contribute, I'm actually, you're my springboard, Mr. Lean. You are. So So for myself, these are the concerns that I'm hearing out in these protests, on emails, and so many concerns from parents. And parents are very upset that they've lost their parental consent rights. What is this government doing to give them back? Why is it mandated? Why can't it be recommended?
Attorney.
As you know, these are issues that you have brought to my attention, and this is the very reason that we wanted to set up a briefing with you with Professor Joe Doyle, and we will facilitate that so that you can have those conversations. And I've got a little bit of information here which is following up from our meeting as well, which may be of assistance.
Mr.
Thank you, Deputy President. I'd like to ask a couple of questions about the pandemic powers. I'm not going to talk about vaccines for a bit. So one of the definitions included in this bill is around disease vectors, which is effectively animals that aren't humans that can transmit or carry disease that can be transmitted to humans. And one of the powers in the bill is to quarantine or destroy disease vectors. Can I ask, what's the thinking behind having this in the bill? Because I'm not aware of anything associated with COVID-19 other than I think I read somewhere that cats can transmit it. But is this related to COVID-19, or is this related to envisaged other possible diseases that might need to be controlled?
Attorney.
My advice, Mr. Limbrick, is that this is a provision designed to future-proof the framework and could be any pandemic not specific to COVID.
Ms. Limbrick.
Thank you, Deputy President. I thank the Attorney for a response. Another question around the powers, and sorry, I will talk about vaccines again. With regards to vaccine mandates, which power would they actually be using to implement this? Because to my mind, there's a couple of different powers that they could use here. One could be the requirement to produce information. So, you know, you have to produce your vaccination status, or the other one could be the general power. Which power is it envisaged that mandates, for example, would be enforced with?
Attorney?
Pandemic order.
That's a general power. Oh, okay, thank you.
Ms Crozier?
Thank you, Deputy President. Attorney, I'm referring to the second reading speech again. And the Minister in his second reading speech spoke about implementation of the regulatory framework once the bill passes. And in the second reading speech, it speaks about the operational teams that are preparing training and guidance materials for authorised officers to support the bill's measures to ensure proportionate compliance. So I've got a couple of questions. I'm wondering, how many authorised officers does Victoria now have? I know that we spoke about a number during the state of emergency debate from recollection. Yes, and I think you gave me a number at the time. And I'm just wondering, has that increased? What is the current number of authorised officers currently? And then I'm wondering if you could explain to the committee around that element around proportionate compliance. What does that entail in terms of that training that these authorised officers are getting that is ensuring proportionate compliance will be undertaken?
Attorney?
I'm happy to get you some numbers of authorised officers, bearing in mind that's under state of emergency, not under this bill specifically. But in relation to your questions about the training, it depends on the role the authorised officer would be undertaking. So you might have different training for someone that is meeting people at the airport as opposed to somebody who would be going and visiting those that are in home isolation, for example.
Dr Cumming? Sorry. Oh, is Ms Crozier on a follow-up? Good.
I didn't hear the first part of the question. I think you said that the number of authorised officers you couldn't provide to the committee. Was that right?
No, I was happy to get it for you. The initial advice I have is it's around 400 across the industry and health, but because I don't have that form of advice, I'm happy to follow up and get you confirmation.
Thank you, Attorney, for that confirmation. So in relation to those specific guidance, that is exactly the training that they would get under the current Act, is it not, in terms of the duties they were doing, whether it is if they were doing home visits or if they were working in other areas? So that's exactly what is under the current Act. Is it exactly the same training that would be required under the current responsibilities that they have under the current Act?
Attorney? Dr Cumming.
Attorney, I have a question. I know it falls a little outside of the bill again, but it's around testing, being that there are a lot of questions from the community around antibody testing, and knowing that this government, and you've brought up earlier, the government saying there's a need to keep mandating so that people will actually take their booster shots. And there are people in the community who would like to know their level of immunity within their blood, being that either via their vaccine, if the vaccine's actually worked for them, or that they've had COVID and they want an antibody test to see their level of immunity. So it would seem that you cannot, almost impossible, GPs will not give you an antibody test, even though you've tested positive via a PCR test that you've got COVID, you've been made to self-isolate, and then afterwards they will just talk in general terms that you're shredding. And like I have said, they have been told to go back to work that they have to go down the path of actually getting a vaccine. where they know via a PCR test and isolating and obviously feeling ill from the disease that they've had COVID. So why are they being, why can't they have an antibody test? Why isn't there any level of testing around even the vaccines and how they're working for them?
Refer to my invitation to facilitate a conversation with a health expert. I'm not in a position to give you details in relation to those issues that you raised. They're interesting issues that you've raised, and you have spoken to me about these previously. But again, if it's not Professor Doyle, we will certainly put you in contact with someone that you can tease out these issues with.
Dr. Cumming.
Thank you, Attorney, for that offer. But this is the level of problems that are out in the community at the moment that this mandating has created, because there's a level of misinformation that is fed from the Premier, what comes out of the Premier's mouth in the daily health advice, which is framed in a certain way that it's interpreted down the chain, that the practicality of how it's actually playing out is meaning that normal medical concerns it's not being addressed the way that you would normally deal with somebody who's had a disease that should get a vaccine or not because they've got antibodies. There's no conversation around people's immunity or what kind of immunity they have because they've already had the disease. Even in this place, Attorney, we, as members of Parliament, were thrown out of this place and were told we couldn't turn up and work here at Parliament until we showed our paperwork. We weren't given the option of a rapid test, and we still are not. I'm still here in Parliament and we're still not given an option of having a rapid test. They're not here to be able to work. And for myself, out of the community, everybody wants to go back to work, Attorney, even if they had a rapid test or if they could test their already antibodies, because they could have had COVID during this Delta outbreak, or they could have had COVID last year and not know it. But nobody's allowing them to test their antibodies.
You just taking that as a statement? Thank you. Mr.
Thank you, Deputy President. I've just received a response from the... so there was questions earlier today from SARC to the Minister, and I've just received a copy of the response from the Minister. And I'd like to ask a question about one of the responses. So one of the questions was, can pandemic orders and management powers be used in relation to any diseases and areas? So I think the question was referring to, if you declare a pandemic, then can you use those powers for any disease? And the response seems fairly clear that you can only use it for the disease that's specified in the pandemic declaration, which is fine. But one thing I'd like to ask is, how do we actually define a disease here? Because we've had lots of different variants. Are these variants, if we're defining the disease by the genetic structure, for example, then when we have variants, they're going to be different ones. So how are we going to define the disease in a tight enough way that it will be only for that disease and its particular variants?
Attorney?
Mr Limbrick, I just want to test some of the advice that I've got here. Give me a sec. All right, I'll have a go at this, Mr. Limbrick. A pandemic declaration is in relation to the virus, which is the underlying virus, which may have a variety of variants but still be covered by the one pandemic declaration. If there is a completely different pandemic, so in the current context we're talking about COVID and the different variants that we've come to know by name, would all be captured under the one pandemic declaration. It would, if you had a completely separate one, and I don't know, whatever name it is, virus B, all of a sudden appears completely different to that. It would be open to the Premier to declare a separate pandemic declaration or add it to the existing declaration. It would allow for both under the legislation. Does that answer your question?
Thank you, Deputy President. I thank the Attorney for her answer. I suppose what I'm getting at is in diseases, like what you say, I suppose there's a nomenclature, right? So you have all coronaviruses, which includes the common cold, and then you'll have, the current coronavirus and then variants of that. I suppose what I'm asking at, which level are we expecting to define or declare the pandemic on? Because what I'm concerned about is if we declare it at, all coronavirus level, then you could use emergency powers for the common cold, which would be inappropriate.
I think it has to come back to the requirements to be able to make a pandemic declaration, which require the Premier to be satisfied that there is a serious risk to public health and the serious risk arises from a pandemic disease or a disease of a pandemic potential. And the term serious risk to public health is defined by the Public Health and Wellbeing Act by reference to a number of factors including location, immediacy and seriousness of the threat to ensure that a benign pandemic, common cold, cannot be used as the basis for a declaration.
Thank you, Deputy President. I thank the Attorney for her answer. But it sort of, I think it raises the question though that a pandemic declaration can only happen if we have sufficient knowledge of the disease, like if we've studied it enough to be able to classify it and all of those things. So is that what we're saying here, that only when we have enough knowledge to classify a disease and specify it, that's the only time we can declare a pandemic? Like if there was some unknown disease, for example, God forbid, people started getting sick with some unknown disease, we couldn't actually declare a pandemic until we'd studied it. Is that correct?
That's why the Premier would have to seek the advice of the public health experts in forming a view as to whether there was serious risk to public health.
Ms. Crozier.
Thank you. Thank you, Deputy President. Similar to Mr. Limbrick's question, I was going to ask about endemic. What happens when COVID becomes endemic, so it's present within the community, which I think is sort of what Mr. Limbrick was getting to in terms of the variants and the severity of disease, and like the common cold that is endemic across our population. We could get to a point where COVID is endemic, so there is no pandemic anymore, but that it could be, just bear with me, an outbreak, like the flu, if there was some other serious viral, SARS or MERS. Now, they weren't pandemics, but they were serious outbreaks that caused significant health concerns. So at what point would the government determine that the pandemic was over and now it was endemic? Would that be based on WHO, or is it the government's own interpretation about the severity of disease within the community?
Or is it the Macquarie Dictionary?
Attorney.
Ms. Crozier, once the advice was provided that the pandemic is in fact endemic, the declaration would be revoked, and in relation to who provides that advice, that would be the public health experts that that are well known to the Victorian public, the CHO, and they have obviously networks into the other jurisdictions, and these are the types of conversations that those people have in making giving advice in relation to pandemic or endemic situations.
Ms. Crozier.
Thank you, Deputy President. Well, certainly that's the case, Minister Attorney. We've had the National Cabinet that has got ministers and the Prime Minister and the Chief Health Officers from around the country, and yet there are different decisions made by different governments within our country. No, but with all due respect, I'm talking about that if there is a severe outbreak in New South Wales and it's endemic here, well, let's just put it, it's endemic across Australia. The WHO has ruled out COVID being pandemic by February. Just as an example, you're saying that the government would take advice from the chief health experts, but they wouldn't be necessarily getting, if there was a declaration from the WHO who then declared a worldwide pandemic, which was based, a lot of the advice came to Australia, and that's why we took the provisions we did. Is there not a bigger body like that that the government, I know you're saying that they would look to those other bodies, but if it's declared an endemic, as you said, then the pandemic declaration would not stand. So that would the legislation then be immediately revoked by the Premier?
Attorney?
Yes, if the advice was that the virus is now endemic, the declaration would be revoked because there's no pandemic.
Dr.
Attorney, one of the issues that I've raised a few times in the last 18 months is one about the possibility of having COVID-ready kits or something that the community could actually have at home while they are at home with COVID. And the conversations that we had last time, I'm hoping to know more about how the community can manage COVID at home. Apparently you're currently using a model from the UK, but it would seem that the actual experience of people who are sitting at home with COVID hasn't been that. There's been a lot of people in the community who are either finding their own home remedies or treatment protocols that they've actually seen from overseas, and people who can afford to are able to go get those home remedies or able to import things from overseas, where others, like the vulnerable in my community, are being denied care at home while they've got COVID, being told that they'll have a GP visit or they're getting a phone call and finding out if they've got food, but they're not actually being given any medications or remedies that they could use at home to actually reduce their viral load, so then their COVID doesn't increase or get worse, so that they don't actually end up in hospital.
Attorney?
Again, Dr. Cummings, well outside the bill, but for the benefit of the House, I'll just give some generic information about the issues you've raised about at-home care of positive cases and access to treatment. So thanks to the high vaccination rates in Victoria and the protection that that's providing our population, we've been able to transition the way we respond and manage COVID through a triage system that begins via a survey when patients receive contact from the department that they have a positive result. Some cases can be safely and successfully managed at home. We find that some people prefer to be at home rather than hospital when they don't require more intensive treatments and who do not have underlying medical conditions, especially people who are fully vaccinated. The program monitors individuals with COVID-19, ensures they receive support and care that they need, and anyone who is at risk of deteriorating are identified early and transitioned to higher levels of care. With the support of a patient's GP, they have a telehealth appointment on day 2, 5, 8 and 11 at minimum, and more often if required. If they receive daily text messages to self-enter their symptoms on a COVID monitor. If the patients elect not to receive text messages, then the clinical care team will call the patients daily and enter symptoms directly on their behalf into the COVID monitor. Severe symptoms will trigger a response from the complex care COVID team who operates 7 days a week, and the program ensures that all patients have access to and receive the care they need at the time that they need it. And so I'm happy to provide some of this information, which was a direct follow-up from your and my meeting. But Dr. Cumming, in relation to these kind of matters outside the bill, again, I would ask if we could confine those to a separate briefing with a health expert.
Thank you, Attorney.
Dr. Cumming?
Thank you, Attorney. I do appreciate that. Seeing that I brought this up 12 months ago without having a vaccine around, last year there's 20,000 people that actually had COVID in the community in my area, and this year we've also got a lot of people who've had COVID and obviously haven't gone to hospital, but they've managed it at home. It would seem that I've still, even though the answer that you've just given me, Attorney, it would seem that the GPs and consults, there is a lot of writing down of symptoms, but there's still a distinct lack of understanding of what the treatment protocol is and what GPs actually can hand out and what GPs are actually doing to make sure that those COVID positive patients are not progressing, that their viral load actually stays to a minimum and that they don't actually progress into ending up in hospital.
Six. Dr. Cumming, the Attorney's been fairly generous with answering questions that are outside the scope of the bill, but this questioning along the lines of treatment is well outside the scope of this bill. So we might ask you to take those questions offline and see if the Attorney can assist you in getting some answers to those questions, but not as part of the committee stage. Thank you. Are there any other questions on Clause 1? Mr Limbrick.
Thank you, Deputy President. I just had a couple of questions relating to timelines. So in the event that this bill passes, the advisory committee and this joint committee will need to be set up within just over a fortnight. What sort of timeline does the Attorney actually think that the advisory committee and the joint committee would actually be set up, and what sort of processes will be used to set that up?
Attorney?
Thank you for your question, Mr Limbrick. In terms of the passage of this bill, we've obviously got until the 15th of December in relation to a pandemic declaration, which would, given our current situation, what we know, would be pretty much a given. The legislation provides for the IMPAC to be established within 30 days, and the requirement to establish the Joint Parliamentary Committee is as soon as practicable. And obviously, as that involves nominations from within the Parliament, we would seek to engage with members of the Parliament to form that committee.
Thank you, Deputy President. I thank the Attorney for her answer. So if I'm understanding you correct, then the Joint Parliamentary Committee wouldn't be formed until the next sitting of Parliament in the new year, or is it possible for that to happen earlier somehow?
Attorney?
Mr Limerick, that's a very good question. The commitment is as early as practical, but you're right, you would need Parliament to confirm that, so we'd have to think about how we would achieve that, but that would be the intention.
Mr Limerick?
Yeah.
Mr Limbrick?
Thank you, Deputy President. I thank the Attorney for her answer. With regards to the advisory committee, has any work been done already on identifying and, I don't know, tapping people on the shoulder? Because it seems like a big job to get such a wide and diverse group of experts together, and even within 30 days, I imagine that would be a difficult task, considering these people are not just sitting there waiting to get onto this committee. So what sort of work has already been done there?
Attorney?
Mr Limbrick, we are keen to establish that quickly, but would have been inappropriate to preempt the passage of this bill, so an EOI would be put out as a matter of priority once this bill has secured passage through the Parliament.
Ms Limbrick?
Thank you, Deputy President. I thank the Attorney for her answer. Do we have any idea of how these committee members, will they be compensated somehow for their service on this committee?
Attorney?
Yes.
Thank you, Deputy President. And I think the Attorney already knows what my next question is going to be. How much?
Attorney?
It is outside the scope of the bill, but technically outside the scope of the bill because it's not provided for in the bill. However, I'll take that on notice and get you some further information because there's no problem in making that information public.
Ms Lim?
Thank you, Deputy President. I thank the Attorney for her answer. But I would have thought that this would be considered, surely.
The government have remuneration guidelines. It's just a matter of which category they're, like it's not as though we're just plucking it out of thin air. It'd be comparable to other committees. I just don't have the table in front of me. But we have guidelines for these types of things. I just don't know which category they would be appointed under.
Ms Crowe?
I just ask on that, would they be approved by Cabinet then? Would that go through the normal Cabinet process to be approved on the selection and the remuneration?
Mr Ondaatje.
Thank you, Deputy President. Just on that, Minister, will there be a secretariat attached to that committee?
Attorney.
Mr Ondaatje, the answer would be yes. I'll see if I can get any specific more details in relation to that. The answer is yes, and during the second reading debate, during my sum up, this was an issue that was particularly of interest to the Greens, and they asked for confirmation from me via the Minister for Health that this committee would be adequately resourced, and we've given that commitment.
Mr Ondaatje.
Thank you, Deputy President. Minister, how many members are there on the committee?
Minister.
It's not defined and it's not set because we want to make sure that we can have the appropriate experts to deal with whatever situations may be presented to us depending on the type of pandemic and the type of situations that Victoria faces.
Ms Crozier.
Oh, thank you, Deputy President. I mean, we know the type of pandemic that we're currently in, Attorney, so I don't know I just don't understand your response. It depends on what type of pandemic, when we know what sort of pandemic we're in. But will these positions be advertised and go through that normal process? Because that will take some time. My point is, I mean, you're raising to your feet.
Well, it's because I've already answered the question, so rather than you waste time.
They'll be advertised.
So, Attorney, Ms Crozier has the call.
I'm
so
sorry if I missed
you can
that.
resume your seat.
They'll be advertised. Thank you. My apologies.
Okay.
My apologies. I think it was because I couldn't hear you, and I said I couldn't hear you, and I think it's in you answering. So, my apologies.
Ms Limbrick.
Thank you, Deputy President. Does the attorney believe that 30-day time frame is realistic? It just doesn't, like, I've employed many people before, and even for, you know, relatively unskilled positions, it can take a while to get them. And I imagine for very highly skilled people that we would expect to be on this committee, 30 days to me doesn't seem like a reasonable time frame.
Attorney.
30 days after the declaration.
Which would have to be December 16th or something.
Dr Cumming.
I just have one question. I know it's a bit outside the scope too, Attorney, and you've been very gracious in answering some of the constituent questions that we have been raising tonight. This one comes from the Footscray traders, and when the government mandated vaccines, I've got all this tangled around my neck, I'll just leave that be. How did the government come up with the figures for fines? We had obviously the longest lockdowns, and we had 6 lockdowns, and then when vaccines were mandated that you could actually work, we had authorised officers go around Footscray and threatening fines of $100,000. How was the proportionality, or how was that figure arrived, or even the $10,000 fines that were arrived at, or even the $5,000 that were arrived at through this pandemic and lockdowns?
Attorney.
Yes, thank you, Dr Cumming, for your question. The appropriate fine values are determined based on comparison with similar offences or similar conduct. Fines are obviously designed to deter inappropriate behaviour and to apply a penalty for breaches of rules that are set. And as you may be aware, the government, through amendments, has agreed, based on the feedback from particularly our community legal sector, to reduce the fine amount that was in the original bill that was brought to the Parliament, so they will be halved. And we're also introducing a concessional fine regime to enable those people that have healthcare cards to receive a lower fine, which is proportionate to their ability to indeed address that fine.
Ms Barth.
Sorry, just...
Okay, Dr Cumming.
Thank you, appreciate that. Thank you, Attorney, for your answer, but it would seem that even with the amount that was currently, or well, was used after the October 15th in the way of proportionality of the amount that was derived for a fine, normally there is, warnings. The authorised officers would go around and in the current discretion, under the current Health and Wellbeing Act, when a health officer from a local government goes around and, tests or goes and inspects health premises, or, health premises, or they inspect a food premise, it's normally, the fine is really large when there's been an outbreak, such as food poisoning. But just to have these very large fines for people working that are not vaccinated, there is no disease present, they haven't hurt anyone, they haven't given anyone those diseases. How is the government how did the government derive under the Chief Health Officer regulations or directions that was actually seen to be proportionate under the current Health and Wellbeing Act, seeing that normally when we deal with diseases and outbreaks and health risks within the community, such as, like I said, food poisoning. We've seen many a case in Footscray or other places, and then it goes through a process of the courts, and then it goes through a process of seeing how many people were affected by somebody not or passing on or the disease or the health risk. It would seem that these were not proportionate. It was just about a mandate and people not being vaccinated, no disease present.
Cummings, it's important for a system to have adequate compliance and enforcement measures. For serious egregious breaches, it's appropriate that fines be applied, but the practice has been to provide a warning as a preference, particularly for low-level breaches such as not having your check-in thing in the right place and things like that. There's been, I think, as we had a conversation earlier, attention to education and ensuring that businesses in particular know their obligations and requirements and support provided in that regard. But in relation to the fines as set, they were decisions of government. We have committed to halve those in this bill, and that's basically it.
Dr. Cumming?
Yep, and I'm still going to go down this line of questioning because I do not believe that the setting of the fines was considered reasonable or proportionate. Even the halving is still extreme. It would seem that throughout, even within the last 6 months, there's many examples of even when the Premier called a lockdown, people were, not everyone's glued to their phone and wouldn't know what was going on. And then they were, the authorised officers were running around handing out $10,000 fines rather than possibly saying, hey, you might know that we're going into the lockdown, or it would seem that there's been a large amount of examples. And 12 months ago, when we were discussing the state of emergency, authorised officers, I was given assurance by the government that they wouldn't be heavy-handed, that the government would go around. And for myself, my experience is that, the grants that I've heard from the government, that $10,000 to do this, or, small business grants, and you have to jump through heaps of hoops to get any grants and compensation back for the lockdowns. But it's really easy for the government to actually go around handing out fines for non-compliance rather than that proportionate, measured, human and considered response to these small businesses. And it would seem that small businesses were hit more than any other industry. Construction industry doesn't seem to have been given the bigger fines for non-compliance. It would seem that small business has been hit and hit and hit throughout these lockdowns and throughout these mandates. And from being allowed to open, it would seem that they are continuing on with these authorised officers and handing out fines.
Just take that as a statement. Fine, thank you. Mr Limbrick.
Thank you, Deputy President. I just wanted to clarify, there's a mechanism, I realise I'm jumping ahead, but maybe it's best to just acquit it in clause 1 with your, if that's convenient. With regards to the mechanisms for seeking relief for a detention order, on section 165BA 1B, from a detention order. So there's a mechanism that... Does this relief just rely on Section 33 of the Human Rights Charter? So in the Human Rights Charter, it has the ability to refer to the Supreme Court for judicial review. Is that the mechanism through which one can obtain relief from a detention order? Let me come back to you on that one. All
Right. Ms.
Thank you. Thanks, Deputy President. Attorney, just returning to the Pandemic Advisory Committee. So the government is called a pandemic. There's the advisory committee has been established. At what point the government closes down in 1, 2, 3, 6 months, closes down the pandemic? What happens to that advisory committee? Is it disbanded and their remuneration ceases on the spot? Is there ongoing? Are they held? Are they suspended and still, funded, or are they removed entirely?
Attorney?
At the point of a declaration being revoked, the panel would be stood down.
Thank you.
Thanks, Attorney. And that means that their funding would then be ceased. Is that correct? I'm assuming a nod means yes.
They're a fixed-term appointment in connection to the declaration of the pandemic.
Thank you. I'm interested, and I know that in the SARC report or the SARC response from the Health Minister, he talks about a public authority. I'm interested in how the committee reports A, to the Premier and the Health Minister, but also B, for transparency to the community or, the wider Victorian population. Is there any requirement? How can we get to see, as Victorian citizens, the information provided from the advisory committee?
Attorney.
They have to table their advice in Parliament.
Ms. Bath?
And thanks, Minister. And is that specified in a monthly or weekly, or what is the format of that? And would it be individually categorised? So logistics will say, health. Is that what's the sort of format of it, Minister?
Provide advice to the Minister, and under Section 165CG, the Minister has to table it within 4 days.
Ms. Bath, that's it? Are there any further questions on Clause 1? If not, the question is that Clause 1 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Are there any questions on Clause 2 to 3 of the bill? Which clause, Ms. MacArthur? Clause 2. Mrs. MacArthur?
Thank you, Deputy President. Attorney, why does the operation of Division 2 of Part 4 come into effect on a different date?
Division 4.
Ms Crozier called no on that clause.
I didn't hear any no's, so that was my problem. I didn't hear Ms Crozier calls it. So, okay, well, let's just do Clause 1 again. The question is, Clause 1 stand part of the bill. Those of that opinion say aye. Sorry? Well, I didn't hear Ms Crozier say no, so I didn't ask was there a division required.
The
protest comes after a member has even asked a question on clause 2. So whilst I respect if the Deputy President missed it, but it took a full 90 seconds for you to raise it as a point of view. And I'm sitting right here and I didn't hear you say no either.
Okay, so the question is that clause 1 stamp. Sorry? Okay, so we can't re-put the clause. I'm sorry, the clerks have advised me, but we need people to actually call louder because I just didn't hear. And yeah, well, I didn't hear it. I'm sorry, and the clerks didn't hear it either. So yeah, but it's we've moved on. So, Mrs. MacArthur on clause.
Thank you, Deputy President. I'll reiterate my question. So, but the attorney's busy. Oh, she's on the job.
State of emergency. So as you know, the state of emergency was declared 20 odd months ago and we've been here and extending it, and this is to confirm that it will go back to as though the pandemic hadn't, as though the state of emergency hadn't been declared, and revert back to 0.
Is that it? Are there any further questions on clause 2? Mr. Richard.
Thank you, Deputy President. Deputy President, just arising from the Minister's answer to Mrs. MacArthur, is it the government's intention then to proclaim these new provisions as soon as royal assent is received, or is it the government's intention with, as the Minister described, the reset of the state of emergency to continue under the existing state of emergency provisions for the current pandemic at the present point in time?
Attorney?
That would be informed by the health advice, Mr. Rich Phillips.
Okay. Mr. Rich Phillips?
So,
of December. Yeah.
But with the passage of the bill and clause 2 coming into effect, or that relevant provision coming into effect on the 15th, as you've said, the reset of the state of emergency occurs. So you're now indicating to the committee the government may not use these new powers. It may actually use the existing powers. Is that correct?
There'll be no intention to extend the state of emergency. Yeah. Sorry. Yeah.
Okay. Dr. Cumming.
So did we clarify earlier what is the time frame, like weeks, months, years, in the way, without limits, the definition of serious risk to public health? Do we actually define there has been no cases of the disease in Victoria for a period of time? Did we actually define what? Is there going to be a definition to that?
Attorney?
I'm sorry, Dr. Cummings, we're in clause 2, which is about the commencement of the Act.
Dr. Cumming, we've moved to clause by clause now, so it's questions relating to the actual clause before the committee. So did you have any questions on clause 2? Okay. All right. So if there's no further questions on clause 2, the question is that clause 2 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes, no, the no, and I think the ayes of the noes have it. You want a division? I'll call it back. Thank you. The question is that clause 2 stand part of the bill. Those voting in favour of the clause, I invite you to stand in your place now. Thank you. You can resume your seats. Those voting against the clause, I invite you to stand in your place now and indicate my vote is with the noes. Thank you. You can resume your seats. The results of the division is ayes 20, noes 17. Therefore, Clause 2 stands part of the bill. Clause 3, are there any questions on Clause 3? Mr Davis.
Just in one sense, it's self-explanatory. In this Act, the Public Health and Wellbeing Act 2008 is called the Principal Act. Do all the objectives and aims of the Public Health and Wellbeing Act apply?
Attorney?
I'll just seek some supporting information to my end. Once these amendments to the Principal Act pass, the objectives would apply because this forms part of the principal bill, but this part has its own objectives as well.
Mr Davis.
So how are the new objectives to be weighted against the old objectives when incorporated in the Act?
Attorney?
Well, that would suggest that there is a conflict. I don't think there is.
Mr Davis?
Often in the current objectives, there is often weighting and balancing, for example, charter-related matters.
Attorney?
Mr Davis, Clause 3 is pretty narrow and this discussion's outside the scope of Clause 3, but I refer you to my previous answer.
Mr Davis?
With respect, it's not outside or, narrow or anything like that. It's introducing new concepts into an Act, and I'm trying to understand the interrelationship with the existing concepts.
We would anticipate that they exist in harmony.
Mr Davis?
With respect, Deputy President, they often don't. So charter objectives, for example, are often in conflict with the public health aims, and one of the key points is that the charter objectives seek to protect human rights, and in many cases the public health objectives seek to override human rights. They are often in conflict, and that is understood, and that is not a failing in the Act. It is actually understood.
Excuse me, can we have some quiet in the chamber, please?
And in that sense, I want to understand how they are incorporated.
So, seriously, their noise level was just extremely high then. I don't know how the attorney heard Mr Davis. So please, can we keep the chatter in the chamber down? Attorney?
Mr Davis, I will just repeat that they will be read harmoniously.
Mr Davis?
with respect, Deputy President, just to assert that they're read harmoniously doesn't actually answer the question. They may well be in conflict in certain circumstances, and perhaps naturally so. So the fact that there are new objectives there, it's a perfectly reasonable question as to how they are to be weighted and balanced.
Attorney?
Mr Davis, the additional objectives have been set out in the new part and in accordance with the ordinary principles of statutory declaration, so statutory construction. So they're designed to fit within the principal bill, so it's not as though that hasn't been thought through.
Mr Davis.
With respect, Deputy President, it doesn't actually answer the question of how they are to be weighted, how the government intends these potentially conflicting matters be resolved.
Refute the suggestion about them being potentially in conflict. Would you like to bring to the attention of the House a conflict that you've identified between the objectives?
Mr Davis.
Deputy President, I've actually just brought one to the House's attention, and that is where a public health order of some type is made, a pandemic order perhaps in this context, and indeed it restricts the human rights of people. Now, that may well be necessary, it may well be in the public interest, but it's not true to say that there is no conflict.
Minister.
This may assist Mr Davis. The preservation of public health will be the primary consideration in making decisions under the pandemic part. This is in line with the broader objectives to the Public Health and Wellbeing Act, which include protecting public health and preventing disease, illness, injury, disability or premature death, and promoting conditions in which persons can be healthy. However, the COVID-19 experience has illustrated the duration and complexity of pandemics, as well as significant impact both on a pandemic and its management have on the Victorian community, means the decision-making in a pandemic context will necessarily touch on a broad range of matters, including social, economic and mental well-being. I think that's just a longer way of saying they will work in harmony.
Mr Davis.
Well, I'll just record that it doesn't actually say that, but and I think there are conflicts, and I'll just record that I don't think the Minister has answered that satisfactorily.
Thank you. Are there any further questions on Clause 3? If not, the question is that Clause 3 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We move to Clause 4. Are there any general questions on Clause 4 before we move to all of the amendments? There's quite a substantial suite of amendments here. Mr Davis.
I have some general questions that relate to a cluster of these definitions, and maybe it's pertinent to do them as a group, as it were, or I can do them individually, as I'm in the committee's hands.
Sorry?
Go sequentially.
Okay. The clerk has suggested you go consequently. Alphabetically.
Sorry. I'm sorry. I'm just trying to understand exactly what that means. Okay. So. The contact tracing information phrase has the meaning it says given by section 165 CB1. Does this include the common definition of contact tracing as would be understood if you looked at the dictionary, as it were, or read the newspaper? Does it have a broad definition of contact tracing?
Mr Davis, the meaning of contact tracing information is very clearly set out on page 58 of the bill. I'm not quite sure how that isn't enough for you. Clause section 165CB. Would you care to read that, or would you like me to read it out for you? I don't really wish to. I'll just draw your attention to it. It's 3 paragraphs that explains really clearly what contract tracing is.
Mr Davis.
My point is it's limited to that. It's not a broader sense of contact tracing in the sense that the community would understand it.
Attorney.
Would refer you to section clause 165CB, the meaning of contract tracing information. I don't see how what's there wouldn't align with what the community's understanding of contract tracing is, but that's my opinion.
Sorry, we're still dealing with Mr Davis has a whole list of these. So, okay. Oh, and the point, Dr. Cummings.
Just taking up a point that the attorney's just raised and Mr Davis has just... So just understanding that, attorney, so it says here, is recorded in any form and whether true or not about an individual whose identity is apparent or can be reasonably ascertained from the information, or is collected by a digital visitor registration system for the purpose of contact tracing, whether or not the information is about an individual whose identity is apparent or can reasonably be... Are you just talking about CCTV in this, or what is meant by a digital visitor registration system, or is that just QR checking?
Attorney? Mrs McCarthy.
Deputy President, Attorney, Clause 4(5) largely replaces the existing Section 3 in brackets 4 with new wording that can relate to any pandemic disease.
So, Mrs McCarthy, sorry, you're moving on to a new section. We might go back
Clause
to...
4?
Yeah, no, but it's not consequential to what Mr Davis was asking. So we'll continue to move through the definitions with Mr Davis. Thanks.
And unless someone's got another one, I want to ask about this disease of pandemic potential definition. And I note the SARC report, and I just record for the Chamber and the community's attention that the SARC answers came at 8:14 today, despite the government having tonight, 8:14 p.m, when the committee had been in operation for a number of hours. And the answer number 1, can pandemic orders and management powers be used in relation to any diseases and areas? And I'm just, it goes on to say, I consider that pandemic orders and pandemic management powers can only be used in relation to the disease referred to in the pandemic declaration, and that can only be used in or in relation to the pandemic management area. It goes, I'll see section 165AM2. For example, a power to prevent or limit entry into a pandemic management area may involve the use of powers in relation to that area, but strictly outside the area. For example, at the border of a pandemic management area to stop people going in. A reading of the power, and I'm quoting from the Health Minister's letter, to make pandemic powers under 165A1 in its legislative context confirms that pandemic powers can only be used in relation to the relevant pandemic disease for which a pandemic declaration has been made. The following provisions make clear that pandemic orders can only be used in relation to the relevant pandemic disease or disease of pandemic potential, which is why I'm asking this at this point, for which a pandemic declaration has been made. And I just want to return to some of the points that were made by Ms Crozier and Mr Limbrick here. This disease of pandemic potential, a declaration can be made regarding a disease of pandemic potential even if there is not a pandemic. Is that correct?
Attorney?
Mr Davis, the bill is crafted in a way so that we can receive advice in relation to the risk that the disease has to be a pandemic. So, as you've identified, if it has the potential to give rise to a pandemic but hasn't yet, it can enliven a pandemic order, declaration.
Mr Davis.
So a pandemic order can be made where there is no pandemic and there's only the potential of a pandemic. Just let it be recorded that that is the case.
Attorney, sorry.
Mr Davis,
Attorney, sorry, Mr Davis actually had the...
Well, a point of
order.
This happens to me quite a bit from members opposite, where they stand up and they say what I said and it's not what I said. So to give me an opportunity to correct them, I think is appropriate, because it is misleading the House when they verbal me and put a contention that is not true. We have gone through in some detail about the requirements and the satisfaction of the Premier that on health advice there has to be a real threat to public health and safety. So I've gone through this suggestion that a declaration for a pandemic will be declared on a whim because there is some vague illness in some far distant land is a absolute furphy. That is not what is intended. It will not happen, and there has to be, I rule it out, absolutely, Mr Ondaatje. There is, if you look at the definitions in the bill, look at section 4.6, talks through the disease of a pandemic potential. It says that at a particular time, if at that time the infectious disease has the potential to give rise to a pandemic but is not yet pandemic disease, or any of the following apply. Before that time the infectious disease was a pandemic disease. At the time the infectious disease is no longer a pandemic disease, or at the time the infectious disease has the ongoing potential to give rise to a pandemic. So to suggest that I have said anything that would give rise to anyone believing that a declaration can be called when there is no threat, no risk to public health and safety is not true.
Mr Davis.
Record that when you read it out, it actually sounded precisely like what I just said. So further in the advice from SARC, Section 165A(k)(3) as proposed to be amended by House amendments, and this is where the interplay of these amendments comes in, and if so amended, will provide that differentiation under that section is to be relevant to the serious risk to public health posed by the disease specified in the pandemic declaration to which the pandemic order relates. And I wonder if the Minister might enlighten us as relevant to the serious risk of public health. What exactly does that mean?
Attorney. The Attorney's looking for that. We might call Minister Tini.
Thank you. Pursuant to Standing Order 4.08, I declare the sitting be extended by up to 1 hour.
Thank you. Attorney.
Davis, I did just seek some advice from the box because I got a bit lost in your question, but so did they. So could you just go through that again?
Response that was received today from the Minister for Health, and I've just quoted directly from it here, Section 165A(k)(3), as proposed to be amended in the House, Section 165A(k)(3), as proposed to be amended by House amendments circulated by the Attorney-General, the Honourable Jacqueline Symes MP on the 30th of November 2021. If so amended, will provide that differentiation under that section is to be, and I quote, relevant to the serious risk of public health posed by the disease specified in the pandemic declaration to which the pandemic order relates. And the examples under that subsection refer to a pandemic disease or disease of pandemic potential. And my question thereby relating to this definition and the words in the Health Minister's letter is what is meant by relevant to the serious risk to public health.
Attorney.
Yeah, no, I know where you are now. This is in relation to the House amendments in terms of the removal of the equal opportunity attributes. The House amendment, what the House amendment's proposing to do is to ensure that a pandemic order may be expressed to apply to the following: all persons, specified classes of persons, specified persons, without limiting That's not right. Hang on 2 seconds. I think I know where you are. I think I know where you are at in relation to the issue that you raised, but can you connect it back to clause 4 for me, please?
Well, I'll read it again. Section. This is in the. I'm looking at this in the definitions section here. Disease of pandemic potential. Right. Yep, you can give me the page number there, but section 165AK3, as proposed to be amended by the House amendment circulated by the Attorney-General, I'm abbreviating now, if so amended, will provide the differentiation under that section to be relevant to the serious risk of public health posed by the disease specified in the pandemic declaration to which the pandemic order relates. And the example under that subsection refers to, quote, a pandemic disease or a disease of pandemic potential, close quotes. And consequently, I'm asking the question of what does the relevant to serious risk of public health exactly mean in this context?
Just because it mentions disease of pandemic potential doesn't mean that that relates to clause 4.
But I'm trying to understand what this means in relation to here. And given the subsection to refer to a pandemic disease or
But that House amendment.
Which is one of your definitions in the bill.
Yeah, none of us are following your question. Because your question is related to the House amendment, which seeks to put beyond doubt the fact that the bill wasn't intended to cover attributes in the Equal Opportunity Act such as political affiliation and the like. It's not. No, but it's not relevant to the definition of it. It's like, I'm happy to go over that amendment when we get to it, but it's not relevant to clause 4. But we could talk about any of the definitions that are in here and link it to a clause. Like it's. All right. Let me take that one on notice because I can't understand it and neither can anyone over there. So if we can come back to that clause later, that might be useful.
Just, Mr Davis, do you have more in the definitions part?
When there is another section in here that I do want to ask about, and that is the pandemic management general power and pandemic management order power and pandemic management power, and some of these definitions. Now, and I want to understand how these sections that are referred to work with respect to the definitions. Now, we've seen how some of these management aspects have operated. And if I look, for example, I could have picked up any of these reports, the 15th report to Parliament on the state of emergency. And if I quote on page 10, the acting Chief Health Officer advised the availability of emergency powers, and powers continue to be necessary to manage the COVID-19 threat effectively. And these seem to these definitions relate to the management of a pandemic. Could be COVID-19. It could be another pandemic. But since we have one that we've had close association with more recently, in the same matters at page 28.150 in the same long document, it talks about, I consider the availability of emergency powers remain necessary to manage the threat. So, as part of this management, we have seen the government use orders, various types of orders, to restrict activity, restrict changes, and I just ask, is that what these definitions relate to? Pandemic management general power, pandemic management order power, pandemic management power means a pandemic management general power or a pandemic management order power. I'm just wanting you to elucidate what this means. This is meaning in the same way as we've observed with the recent reports, the use of management in that context.
Mr. Davis, with respect, you know the answer, because it's really, really clearly set out on pages 36 and 37 of the bill. It goes, and 38, it goes into really specific detail about pandemic management general powers are as follows: to take any action or give any direction to detain, other than to detain a person that an authorised officer believes necessarily reasonable to protect public health, or to detain a person in a pandemic management area for the period authorised officer believes reasonably necessary to eliminate, reduce serious risk to public health. It goes on to talk about restrictions to movement, how to require movements into and from pandemic managed areas, prevents or limits entry to areas, requires a person to refrain from organising or participating in a gathering whether public or private, requires the use of personal protective equipment, requires persons to refrain from carrying on particular activities, requires a revision of information, requires medical examination, requires quarantining, destruction. It's pretty thorough. I'm not sure I can do a better job of explaining what that means than as set out in very prescriptive terms within the bill as provided.
Mr. Davis?
And the orders made under these pandemic management powers, general power and pandemic management order power, will they be backed up by health information of the type we've seen in the past, and with the recent pandemic? And let me be very specific. The government, in each case where an order is made, has behind it the Chief Health Officer currently. It will be different in this bill. It'll be the Minister. In each current case, the Chief Health Officer has a brief that provides a legal backup to their decisions. Will each of these orders, these pandemic management powers means a pandemic management general power or pandemic management order power, will each of these orders have a brief or other document backing them up. And you went down the long list of various things that can be directed, but will there be a document or a brief that supports the use of those powers?
Mr Davis, we're in the definition section of the bill, and as we have outlined, I think a lot in clause 1, the requirements for the minister to publish public health advice, statements and summary of the charter is a feature of the bill, but in terms of more of the operational stuff, that's later in the bill.
What exactly will be published on these orders? What exactly will be published? Will a formal brief be published? Is that what will be released, or will a different document, a summary document, as we've seen with these flimsy reports, will a formal brief be published?
Attorney?
Mr Davis, the orders made by the minister will involve a statement. A statement.
So perhaps the minister would elucidate what that statement is exactly.
Attorney.
What is it? What does it involve?
Attorney?
I can't go into specifics, Mr Davis, but as we have gone through, if the Parliament believes that the material provided is inadequate, there is opportunities for the Joint Standing Committee to look at that, but it is the intention of the government to provide very detailed, relevant information to ensure that the decisions made, the reasons for the decision, the supporting documentation that led to those decisions is publicly available, and that is one of the strengths of this bill.
Let me ground this in a very specific case, and this chamber ordered the release of the briefs with respect to the charter, and you responded to the chamber on the 3rd of the 5th, 2021, and the public documents that had already been released were provided, but a list of 6, 7, 8, 9, 10, 11 is from 6 to 11 documents out of the total of 11, so 5 which were already public were provided. But for example, the cover brief, number 6 in that document that you provided here on that list, cover brief, reissue of public health directions to limit the spread of novel coronavirus 2019. The date of the document was the 2nd of the 8th, 2020. The author of the document was DHHS, and the government claimed executive privilege over that document, saying executive privilege is claimed over the document on the basis that disclosure would reveal the high-level confidential deliberative processes of executive government or would otherwise genuinely jeopardise the necessary relationship of trust and confidence between public officials and a minister. Executive privilege is also claimed over part of the document on the basis that disclosure of parts C and D of the document would reveal confidential legal advice of the government's advisors. So it's not an abstract question, this is a recent example, and what I'm trying to understand is what would actually be released in relating to these management order powers when one of these orders is made. What will actually be released? Will the brief behind it, will the sort of reconciliation with the charter be published? What will actually be published, or will executive privilege be claimed over many of these documents?
Mr Davis, I would draw your attention to clause 165AP to B and A. Sets it out pretty clearly, but someone of your experience would also know that no, it is not the intention of the government to table briefs.
Mr Davis.
I am, Deputy President, very disturbed to hear this because this is actually the legal documents that actually stand behind many of these points. Many of these decisions actually have a brief behind them that actually empowers an official, that actually gives a legal weighting to their set of decisions. And this is what has troubled me about this bill, or one of the key things that's troubled me about this bill and the government's flimsy proposals to publish additional information, it says, but actually when we get to the heart of it, the government is actually not going to publish the critical documents, the documents that actually empower, the documents that actually balance and weight all of these things. And well, it is actually true. It is actually true. If the briefs are not going to be published, we will not see the actual clear, full reasons, unadulterated, unredacted, undoctored, undiluted by the government. So I am very concerned, and I remain very concerned and become more concerned as we progress, that what we're going to see is the government use this approach to hoodwink the community again, that we're actually going to see the actual briefs, the actual documents on which these decisions are made. And I'm not going to say more on this, but not at this point anyway. I will just record that I am very concerned at what I've heard.
That's quite a performance, Mr Davis. I can assure you that the government has full intention of following the bill, and it requires that a copy of or a written record of the advice given by the Chief Health Officer in relation to the making, variation, extension or revocation of the order will be tabled. A statement of reasons for the making, variation, extension or revocation of the order will be tabled. The reasons the Minister is making an order will be tabled. So your fears are misguided, and I can assure you this government doesn't operate like that. We have committed to doing what we say we will do, and that is tabling the information for the public's interest and indeed for your own interest.
Mr Davis.
Let me just record the kind of antics that the government has got up to on this. And I've watched the Premier in the other chamber. He's got up and he's held this document, he's put it down on the table and he said, here's all the health advice. But of course it's a lie, it's a complete lie. There's the orders that are attached, and then if I could go to any date you choose, but where there's been an order made. On here we look at the 30th of December 2020, the New South Wales Border Crossing Permit Scheme Direction number 3, and it talks about revoke, the earlier one, persons who have been in these areas in specified time frame are permitted to enter Victoria, blah, blah, blah. And then it does give a reason. It gives a single paragraph reason. That's what it does. It says the exercise of these emergency powers have sought to extend
Mr Davis, the Minister on a point of order.
Deputy President, I would ask that the member be brought back to the clauses definition, the definition clause of the bill. We are on clause 4. And Mr Davis is continuing to make long-winded statements, and I think he is repeating himself.
On the point of order,
Mr Davis.
Directly talking to these 3 definitions here, including the pandemic management power and the pandemic management order power, I am, and I'm asking how this is going to work in the context of the decision-making around these items. And we have before us a very similar recent example, and I'm quoting just something from 2020 here, where the government has said, and I've watched the Premier say...
Yeah, Mr Davis, to continue the stage.
I'll be brief, but the exercise of those emergency powers sought to extend existing restrictions to persons who have been in the Blue Mountains, Wollongong area, the latest information, to reduce the risk of incursions of COVID-19 in the community in Victoria. That's the reason. That's one reason, but there's no detailed balancing. There's no detailed discussion of charter issues. There's no detailed discussion of the other aspects of the Public Health and Wellbeing Act, the proportionality questions, the transparency questions, the accountability questions. None of those are touched in this document. And frankly, I am very concerned that what we're going to see is the same sleight of hand occur here, where the government gives a trite simple little explanation, but doesn't actually release the detailed information. And what we've heard now makes me very concerned that the Minister actually intends that the full formal briefs are not released.
Ms Barth.
Thank you, Deputy President. Attorney, this is in 4 subsection 1, pandemic management area. I'm interested to know the definition of area. So it could be applied to an LGA, a local government area. That's my question. A suburb, a town, a pandemic declaration. It could be a street. It could be a particular business. It could be this particular room. So it can actually be quite finite. It could be on a particular, it could be on a church or a school or the like. Is that correct? There's no non-size. It can be a small, it can be, yes, or the whole of the state.
Attorney? Thank you. Okay. Mr Rich-Phillips.
Thank you, Deputy President. Minister, can I ask you about subclause 3 on page 5, which goes to or amends the definition of prescribed senior officer to add in the Principal Act to add a reference "or is an employee of a health service." Now, employee of a health service is not defined in this bill, and it's also not defined in the Principal Act, neither health service or employee. So, are there any constraints on who is an employee of a health service for the purposes of this provision? Exactly.
Attorney?
Phillips, I advised it is the natural meaning of an employee and a natural meaning of the term health service.
Mr Richard.
Thank you, Deputy President. Thank you, Attorney. So an employee would be the cleaner of engaged by a health service as an employee, if they're employed, or it would be the gardener engaged by a health service as an employee if they meet the legal definition of employee. Given that, why does this bill provide for someone who may be the cleaner at a health service or the gardener at a health service to be declared as a prescribed senior officer for the purpose of delegation under this bill?
Attorney?
It's not an automatic entitlement to be appointed as a prescribed senior officer. It's just the eligibility of an employee of a health service to ensure that we can pick up all of those people that would be suitably qualified and experienced to take on that role. So there's still the appropriate selection process or identification of relevant people. Just because it's a broad definition does not automatically give you both titles.
Thank you, Deputy President. Well, Attorney, to go to the Principal Act and the amendment that you are adding, sorry, I'll just find it. It's on page 16 of the Principal Act. It states, prescribed senior officer means a person who is of a prescribed class of persons, being a person who is employed under Part 3 of the Public Administration Act, or other than executive of that Act, and you're now seeking to add, or is an employee of a health service. So the Principal Act and this definition you're inserting will mean that anyone who is an employee of a health service is within the definition of a prescribed senior officer. So it's not maybe in that class, will be a prescribed senior officer. So as Ms Barth said, the Friday night cleaner will fall within the definition of prescribed senior officer. Now, a separate question is whether they are given a delegation or not, but the base definition of prescribed senior officer will include all employees of all health services. Is that correct?
Attorney?
Yes, but they still have to be prescribed, so it's not an automatic right.
Mr Rich Phillips.
Thank you, Deputy President. Well, Minister, if you could refer to the Principal Act and outline where that requirement is, because the Principal Act actually describes anyone falling in that class as a prescribed senior officer, and your amendment will extend that class to include an employee of a health service. So it's not subject to selection. Anyone who is an employee of a health service automatically, by this definition, becomes a prescribed senior officer.
Attorney?
We would maintain that you'd still have to be prescribed.
Mr Rich Phillips.
Thank you, Deputy President. Well, Minister, what's the mechanism for that then? Because I'd argue the Act does that. So if you're saying that's not the case, can you point to where the mechanism is that will allow someone to be prescribed or not prescribed? Because the definition itself prescribes someone in that class.
Attorney?
Yes, but if you refer to page 15, Mr Gordon-Rich, I must give you too many names, sorry. Mr Rich Phillips, prescribed means prescribed by the regulations. So if you read page 16 in conjunction with page 15, I think it would become clear that it is still required to be prescribed.
No. Mr Rich Phillips, have you got more questions?
Thank you, Deputy President. Thank you, Minister, but it's not... I see the reference you're making on page 15, but that is not... That may be the case with respect to a prescribed class of person, which is within the definition of a prescribed senior officer. But the section you're now seeking to add by way of the clause in the bill, or is an employee of a health service, does not say is a prescribed employee of a health service. It simply states is an employee of a health service. So there is no requirement in the element you're adding for a person to be prescribed within that category in order to become a prescribed senior officer. The use of prescribed twice in this principal definition is unhelpful, but the element you're seeking to add doesn't require that prescription. Yes, where there is a prescribed class of person in the principal definition, I agree with you that that requires prescription by regulation, but the element you're adding does not require prescription. It simply declares is an employee of a health service, not is a prescribed employee of a health service.
Attorney?
Mr Rich Phillips, we're really getting in the weeds here, but if you look at prescribed accommodation, for example, the prescribed accommodation means any of the following which is prescribed or is a class which is prescribed to be subscribed accommodation. It lists camping grounds. Not every camping ground is going to be prescribed unless it is prescribed by virtue of the legislation. So I can only reiterate that prescribed is defined in the Principal Act to mean prescribed by regulations, and that would apply to the definition of prescribed senior officer.
We might just have, the clerks have actually organised some supper and there's to be a 15-minute break, and now I'm resuming the chair at 10:45, is that right? Yeah. Mrs MacArthur.
Thank you, Deputy President. Attorney, clause 4(5) largely replaces the existing section 3(4) with new wording that can relate to any pandemic disease rather than just COVID. Why are you proposing to change the wording of this provision so that the expanded definition of serious risk to public health applies to the entire Act rather than just Division 3 of Part 10 as the existing provision applies?
Attorney.
Sorry, Arthur, just simply that the existing clause just related to COVID, and this is to ensure that it can relate to a new pandemic disease, which is, as you would appreciate, the intention of the bill is to be pandemic specific, but not specific to a particular pandemic.
Thank you, Deputy President. Thank you, Attorney. Then specifically, which other provisions in the Act that use the phrase serious risk to public health does the government believe that this expanded definition is required for?
Ms MacArthur, it's changing the definitions so that the Act can take into account the new definition. The words pandemic disease are only used in the new part of the Act, so the bill.
Mrs MacArthur.
Okay, then in clause 4(5) again, the definition of serious risk to public health includes circumstances in which there have been no cases of the disease in Victoria for a period of time. Attorney, how long does the government anticipate a period of time to be?
Attorney.
That would be informed by health advice and as appropriate.
Mrs MacArthur.
Thank you, Deputy President. So, Attorney, under this provision, could there conceivably be a serious risk to public health when there have been no cases of the disease in Victoria for a year?
Attorney.
Ms MacArthur, we've gone through extensively the the definition of serious risk and how the health advice would inform whether a pandemic declaration can be made to respond to that risk. There is no restriction on the timing, but for example, there could be cases in other jurisdictions which would enliven the public health advice, or it would enliven the definition of serious risk by virtue of what the public health officials tell us.
Mrs. McCarthy.
Thank you, Attorney. In that case, it could be for 2 years or more.
Attorney?
I would bring you back to that there has to be the existence of a serious risk at the time that a declaration of a pandemic is made.
Attorney, what if the federal Chief Health Officer or the federal Minister said there was no serious risk? Would the Victorian government, would this legislation act unilaterally?
Attorney?
Ms MacArthur, the advice would be that the CHO can take into account advice such as from the Federal Health Officer. The Independent Advisory Panel can also review the decisions that a Minister makes, and indeed the health advice as provided by the CHO. But I would put on record that we're not aware of any dispute between the health officials in Australia in relation to the existence of a pandemic, for example.
Mrs. MacArthur.
President, thank you, Attorney. I just wanted to be clear that that then you would be acting in unison with federal advice.
Attorney.
It's been the practice, yes.
Mr. Hayes.
Thanks, thanks, Deputy President. I just wanted to ask, Minister, and I'm not sure if this is the relevant place to ask it, but probably it could be. I wanted to ask her, what's the difference between a detention appeals officer and a detention appeals registrar, and why is their method of appointment different, like one being appointed by the Secretary and one being appointed by Governor in Council?
Attorney.
Registrars support the scheme, which is a different role to the officers.
Sorry, I'm not trying to be difficult, but I just wondered what you mean by support the scheme. Are they involved in the review of a complaint against or someone objecting to a decision?
Registrars are administrative and don't make decisions.
Mr. Rich-Phillips.
President. Minister, I'd like to reluctantly take you to the definition that's inserted of pandemic disease in this provision, which is a little bit circular. It's on page 5, and it's proposed to be inserted as a new subsection 5 after section 3, subsection 4 in the Principal Act. For the purpose of this Act, an infectious disease is a pandemic disease at a particular time if at that time there is a pandemic outbreak of that infectious disease. Now, pandemic disease is not used anywhere else is not defined anywhere else in this bill. It's not defined anywhere in the Principal Act. Can you explain what a pandemic outbreak is, which gives rise to the definition of pandemic disease? Is there a recognised definition of pandemic outbreak? Is it something that's declared by the WHO? Is there a trigger for something to be a pandemic outbreak and hence flow to being a pandemic disease?
Attorney?
This has come up a lot, Mr. Rich Phillips, in terms of the term pandemic and can it be defined in the bill. And we note that the terms pandemic disease and disease of pandemic potential are defined in the new subsections 3, 5 and 6 inserted by clause 4. And in terms of defining the word pandemic, pandemic events by nature and complexity can continue for an extended length of time, up to years. The Chief Health Officer can provide advice to the Premier on the threshold of pandemic disease, and there are no widely accepted objective criteria on this threshold, as demonstrated by the World Health Organisation's delay in declaring COVID-19 a pandemic in early 2020.
Mr.
Thanks, Deputy President. Thank you, Minister. I guess the challenge here is this definition goes to a new definition of pandemic outbreak, which, as I said, doesn't appear anywhere else in the legislation, the Principal Act. It's been introduced as a new concept, and I've obviously heard, excuse me, what you've said previously about risk to public health, etc., in terms of describing a pandemic, but this definition takes us back to the need for a pandemic outbreak. So can you put some clarity around what that pandemic outbreak is, which is really a prerequisite for all the other elements that you've talked about with serious risk to public health, etc.
Attorney, just before you answer that, I'll call the Minister.
Thank you, Deputy President. I move pursuant to Standing Order 408. I declare that the sitting be extended up to 1 further hour.
Attorney?
You can't.
Pursuant to Standing Order 4.08, I declare the sitting to be extended by up to 1 hour, and I declared it the first time.
Yes, thank you. The ordinary meaning is what is intended here, Mr. Rich Phillips. It's widespread or global outbreak of a disease, and I would draw your attention to page 7 of the XMEM, which is quite useful to address the issues that you've raised.
Mr. Rich.
Thank you, Deputy President. Thank you, Minister. So that, maybe to short circuit, a pandemic outbreak does not require a declaration or a recognition by WHO or any other international body of a pandemic. It can be determined by other local criteria, like you've spoken about previously.
Yes, but it still has to enliven other relevant sections of the bill in relation to posing a serious risk.
That's it. Dr. Cumming.
Thank you, Attorney. And I'm going to go back to some of the, I know we're in clause 4, but we've been talking about definitions and pandemic, and of course we're here today to obviously talk about COVID. One of the issues that I raised earlier was around immunisation or being immunised against COVID, and some of the questions that you couldn't answer earlier. I went off to just get some further information. One was around the Targi.
Sorry, Dr. Cumming, we're on clause 4 and we're now doing very specific questions about the clause. If you're just wanting to get information on vaccinations, I appreciate your interest in this, and I think we are all interested in that as well, but you may need to do those as questions on notice or supply a list of questions to to the attorney to get an answer from the Health Minister for those. I'm sorry, they just don't fit with this clause. Okay.
That, because within page 5, it talks about the serious risk to public health, and we're talking about this in the way of the pandemic disease.
We're talking about, clause 4 is about definitions.
Yeah, that's
and
correct.
defining those things. It's not talking about vaccinations at all.
Specifically, but it's very broad in the way of the definitions, and it actually talks about...
Yeah, so I'm sorry, Dr Cumming, the questions about vaccinations don't fit in this clause of the bill. In fact, they're outside the scope of the bill. So I would suggest that you do give us a list of questions to the attorney to try and get some answers. And I'm sorry, we're all interested in the answers to the same thing as you, but they just don't fit within this part of the bill. I'm sorry. Okay, so if there's no further specific... You have got a specific question on clause 4? Okay, Dr Cumming.
Wait 1 moment. I'll just... So clause 4, page 4, line 22 to 24, my amendment's talking about omitting all the words, the expression on those lines.
Sorry, Dr Cumming, we're just about to start the amendments. You want...
Oh, okay.
I suppose you can speak to it now, actually, because I think is this the one where your amendment... I know.
Otherwise, I've got a question.
Sorry, can we just... Okay, if you'd like to speak to your amendment, the thing is that you can't move your amendment because it's identical to the minister's, but you can either speak to it right now or you could wait till we get to when we move that with the minister and speak to it then at that point when it's relevant to the amendment that's before the House, to the question that's before the House.
On the clause, but currently I have questions on. So my question is on page 5, under section 5. What is the time frame? Weeks, months, or years? Under 4B, it says in the bill there has been no cases of disease in Victoria for a period of time. What is the time frame? Weeks, months, or years?
Attorney?
Undefined, Dr Cumming.
Dr Cumming?
And then my next question, on the same page, a little bit further down, it talks about obviously pandemic disease, disease of pandemic potential, which was raised earlier by others. So whose advice is it? Is it the Chief Health Officer or the World Health Organisation?
Attorney?
Dr Cumming, the Chief Health Officer provides advice to the Minister taking into account epidemiology around the world and here at home, but we haven't referred to the World Health Organisation in the bill.
Dr Cumming?
Thank you, Deputy President. And obviously, when we've seen the Chief Health Officer's advice, directions in the past, it has a bit of a summary at the very start. It talks about the World Health Organisation, when the pandemic was actually declared. It goes into some further information around that. So I've seen that within the directions. But there is no reference to the World Health Organisation within the declarations of a pandemic or the definitions of a pandemic.
Attorney?
Dr. Cumming, the Chief Health Officer can provide advice to the Premier on the threshold of pandemic disease that poses a risk to the health of Victorians. Objective criteria that are widely accepted does not exist, as demonstrated by the World Health Organisation's delay in declaring COVID-19 a pandemic in early 2020. Using the World Health Organisation's declaration of a pandemic may seem like an obvious way to define a pandemic, but in fact it presents several issues. A good example of this is the current pandemic. On the 25th of January 2020, the first case of COVID-19 was diagnosed here in Victoria. The World Health Organisation declared an outbreak of a public health emergency of international concern on the 30th of January 2020 and didn't declare a pandemic until the 11th of March. So while Victoria didn't declare a state of emergency until the 16th of March, when the CHO provided advice to the Minister for Health that COVID posed a serious risk to public health in Victoria, that is how we should be managing and responding to public health risks, not waiting for an international body to issue advice which may be delayed and put the health of Victorians at risk.
Dr. Cumming?
So just through the Deputy President, just to understand that, obviously the World Health Organisation made that declaration in January. We understood there were cases, and then under the state of emergency, the Premier or the Health Minister or the Chief Health Officer made those declarations here in Victoria, but it would seem that even currently under the new strain, there's obviously World Health advice that's taken into consideration. I don't understand why that in a pandemic situation, which is normally from the World Health Organisation, because they're the peak body to look at outbreaks of infection across the world and then highlight that to countries so that they can make their own decisions. I really do struggle to see how you couldn't actually straddle both in the way of definitions, making sure that there is a provision in this bill to talk about the World Health Organisation and the way that they declare a pandemic outbreak of an infectious disease, as well as the possibility of a localised outbreak of an infectious disease that you would actually declare and raise to the World Health Organisation. But it would seem that this is written in a way that it's just a Victorian pandemic.
Minister?
Thank you, Deputy President. Dr. Cumming, the bill still requires that there must be a serious risk to the public health of Victorians as a result of a pandemic or disease of pandemic potential. The experience is that, of course, our public health officials consider and take advice from the global stage, from experts, from the concern of cases coming into across borders into Australia by a variety of means, but I guess that might not necessarily be the case. The World Health Organisation might declare a pandemic somewhere that is of no risk to Victoria. So the basis that we want this framework to operate on is that there must be a risk to Victorians from a pandemic or potential pandemic, and we believe that in practice there would be consideration of the World Health Organisation, but we don't necessarily need to be reliant on them or beholden to them.
Dr. Cumming.
Just on that, so one of the concerns that were raised and from others with legal minds when they looked at this, that the problem here is that it doesn't really, it talks about the potential, but it doesn't talk about the disease or the cases and the amount. It just talks about pandemic potential. So this is where we fall short of some of the lockdowns and some of the experience that this state has found was when we were chasing COVID zero. That really, the amount of cases within the community not necessarily has the potential to be a pandemic. And I'm not saying with COVID, but this is seeing that we're making laws for future pandemics and diseases, that there should be, there should be an amount of disease or cases or a measure for that declaration to be declared.
Attorney.
Dr Cumming, the measure is on the advice of our public health officials, taking, and as they always do, taking into account a range of local and international intelligence. But I think I've addressed your issues in our previous discussions.
Mr Hay.
Thank you, Deputy President. Minister, I just wanted to say, while I was someone who, in discussions with you and the Health Minister, was talking about a better definition of, a tighter definition of what constituted a pandemic for consideration, I just wanted to say in relation to Dr Cumming's amendment, even though that is sought there, I can't support it for the very reasons that you raised about the World Health Organisation and the delay that came from them about COVID-19 in declaring that a pandemic. So I welcome the attempts to get a better definition, but can't support the amendment.
Mr.
Can I just put on record our agonising over this, because I think Dr Cumming has actually tried to get a tighter definition. We have our moments, of course, with the World Health Organisation. Let me say it's an imperfect body, but I suppose the same as all human institutions, but it's an especially extra dose of imperfection from time to time. But and that makes us somewhat nervous about being shackled more formally to it. Notwithstanding that, I completely and utterly understand what you're trying to achieve with this. We think a lot of this is too loose, and I see that you're trying to more sharply define this. I just don't think in this occasion we can support it, but, you know, look, this would be a classic case where a proper process that had proper public input more broadly, actually over a longer period, would have actually dealt with these sorts of points. We simply couldn't deal with every aspect of the bill that was flawed, and this is one of them, and you've had a go at it, and I'm not disrespectful of that at all. I kind of see the point.
Thank you. We might actually get to some of the amendments now, and I'd ask the attorney to move her amendment number 1, please.
Thank you, Deputy President. In relation to my amendment, this is purely quite straightforward in relation to the definition section. We've gone over these in our discussions and inserting new definitions, so moved.
Are there any, does anyone want to speak on the Attorney's Amendment number 1? Mr Rich Phillips.
Thank you, Deputy President. Minister, I do have some questions on this, and I'm happy to either do them now or when we get to your proposed clause 10A inserted, which is a substantive clause. But I was wondering, can you outline to the committee that you're proposing these as suggested amendments? Can you just outline why they're suggested amendments?
Yes, Mr Rich Phillips, the advice of drafters and the clerks is that because of the financial implication of the detention appeals officers in particular, that it's their advice that they should be suggested amendments because of the appropriation attached to that.
Mr Rich Phillips.
Thank you, Deputy President. Minister, I assume that's because of the remuneration provisions. Are you able to outline how much that appropriation is for this function?
No, I don't have that. Sorry, no.
Mr Rich Phillips.
Thanks, Deputy President. I might leave the substantive questions to the substantive clause on this. Thanks, Deputy President.
Is there any further comments on the Attorney's Amendment number 1? Dr Cumming?
Just in relation to the detention appeals officer and the register, for myself, does this actually just fall within the guise of a pandemic? Seeing that the word detention is obviously used throughout the Health and Wellbeing Act, and detention, the word detention's used in a medical setting, such as, and I've given these examples before, when someone's having a mental health episode and they become a voluntary or non-voluntary patient, and there are a list of how they can appeal, or within 28 days, or so to speak. So with these definitions of this new detention appeals officer, detention appeals register, detention review officer, and then the definitions and the uses of them, will they only be subject to a pandemic, or can they be used throughout the Health and Wellbeing Act in other ways, in other health situations?
Attorney?
These roles are established in relation to this part and only in relation to detention as per a pandemic declaration.
Thank you. If there's no further question, the question is that the Attorney's Amendment number 1 be agreed to. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Attorney, I'd ask you to move your Amendment number 2, please.
Again, Deputy President, we are making minor amendments to definitions and so moved.
Are there any questions? No? If not, the question is that the Attorney's Amendment number 2 be agreed to. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Attorney, I'd ask you to move... I'd ask you to move your Amendment number 3, please. And this is, as Ms Cummings' Amendment number 1 is identical to the Attorney's Amendment 3, Dr Cummings won't move her amendment. Thank you.
This has been well canvassed and no, I've got at least one vote, so moved.
Any questions? Mr Hayes.
I just want to ask the Attorney, thanks Deputy Chair, does this stop, if we're moving SARC from the definitions here, does that stop SARC from carrying out their usual work in relation to pandemic declarations or orders made under the pandemic declaration?
Attorney?
I can confirm the answer is no.
Thank you. If there's no further questions, the question is that the Attorney's Amendment number 3 be agreed to. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Attorney, I'd ask you to move your amendment number 4, please.
Isn't this just consequential? No? I think I did that by virtue of... Still need to move it? Consequential, so moved.
The question is, are there any questions? No? The question is that the attorney's amendment number 4 be agreed to. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Dr Cumming, I ask you to move your amendment 2 to 4, please.
And I'll just read in my amendment, which is obviously clause 4, page 4, line 22, 24, omit all the words expressed on those lines. This removes the definition of scrutinies and acts, which we just did. Committee, as well as known as the committee, isn't going to provide effective, unbiased oversight, and I think it should be removed from the bill, which we've done. Clause 4, page 5, line 24, 25, omit there is a pandemic outbreak of the infectious disease and insert if it's declared or otherwise assessed by the World Health Organisation to such a disease, the current definition of the word pandemic. To define pandemic, the World Health Organisation declares pandemic disease as such, and it should be reflected in the definition. Clause 4, page 5, omit 28, omit if and insert if at any time, if not a pandemic disease, not in the subject of a pandemic health emergency of international concern, as determined by the World Health Organisation. And 4, clause 4, page 5, line 24 to 34, which is on page 6 of the bill. Line 1 to 5, omit all the words expressed on those lines. Again, the World Health Organisation declares an infectious disease, and that could later become pandemic as a public health emergency of international concern, such as COVID-19. The World Health Organisation declared the outbreak as a public health emergency of international concern on the 30th of January 2020 and as a pandemic on the 11th of March 2020. The definition recommended is in keeping with that. So amend the definition of pandemic disease and the disease of pandemic potential to relate to the declarations made by the World Health Organisation. And I'll move them all together.
Thank you. Are there any questions or comments on Dr Cumming's amendment? Attorney, did you wish to make any comment?
I do thank Dr Cumming for bringing this conversation to the chamber. As we have indicated, we're not in a position to support the amendment, but I concur with Mr Davis. On the face of it, there's some merit in it, but it just in a practical sense would be potentially lead to unintended consequences. But of course, we value the advice from the World Health Organisation, and as such, it would be part of the basis of the CHO's advice, is our expectation.
Thank you. The question is that Dr Cumming's amendments 2 to 4 be agreed to. Those of that opinion say aye. To the contrary, no. I think the noes have it. I'll ring the bells. The question is that Dr Cummings' Amendment 2 to 4 be agreed to. I invite those who are voting in favour of the amendment to stand in their place now.
Okay, 3. Thanks, Wendy.
You can resume your seats, thanks. And I invite those voting against the amendment to stand in their place now and indicate my vote is with the no. You can resume your seats, thanks. The result of the division is ayes 3, noes 32, therefore the amendments are lost. This clause will just stand postponed because we do have suggested amendments to clause 4. Are there any questions on clause 5 to 8 of the bill? Which clause, Dr Cumming, please? Clause 5? There's no amendment to clause 5. You have a new clause to insert after clause 8. That's your amendment number 5, not clause 5. Are there any questions on clauses 5 to 8? Sorry, can somebody tell me which clause they want?
5 and 6.
On clause 5? Yep. Mr Davis.
So these clauses are about delegations or the exercise of powers, and the Secretary can delegate any prescribed senior officer. Any, I take it, means any, and what will be the criteria?
Mr Davis, this is a very standard delegation clause, so well versed in the public sector.
Mr Davis.
So what will be the criteria for that delegation?
Attorney.
Explanatory memorandum goes through some of these issues, Mr Davis, so I would encourage you to read that. But the delegation just let me check one thing. Yes, Mr Davis, I would refer you to the explanatory memorandum which specifies that delegations will ensure the Secretary is able to delegate to skilled workforce where appropriate, including to utilise surge capacity to assist in responding to a pandemic. And as I discussed with Mr Rich Phillips, there is the expansion of the prescribed senior officers to include health employees of health services. So the delegation would happen in the normal way in the public sector, and that is only to appropriately qualified, experienced people that are eligible as a prescribed senior officer.
Are there any further questions on Clause 5? If not, the question is that Clause 5 stand part of the bill. Those of that opinion say aye. To the contrary, no. I think the ayes have it. Clause 6, Mr Davis? No. If there's no further questions on Clause 6, the question is that Clause 6 stand part of the bill. Those of that opinion say aye. To the contrary, no. I think the ayes have it. Clause 7, Mrs MacArthur.
Thank you, Deputy President. Attorney, Clause 7 expands the functions and powers of the Chief Health Officer to include having to provide advice to the Premier in addition to the Minister or Secretary. So, Attorney, has the government received any legal advice that due to the absence of this amendment they may have been running the risk of falling foul of the law due to the Chief Health Officer directly advising the Premier?
Attorney?
Falling foul of which law? No.
Mrs MacArthur.
Thank you, Deputy President. And Attorney, during the COVID-19 pandemic, has the Chief Health Officer ever refused to advise the Premier because it is not his current function and power under the Principal Act?
Attorney?
My advice is no.
And Mrs MacArthur.
Attorney, why is this amendment necessary?
Attorney?
This is to ensure that it is beyond doubt that the Premier's role and the new role of the CHO under this framework is reflected. The Premier is to take into account consideration of the CHO before making a pandemic declaration.
Mrs MacArthur.
Deputy President. Attorney, then, just please confirm, is it presumably then solving an issue that presented itself over the past 18 months? Otherwise, it would not have been included in this legislation, we assume.
Attorney? Okay. Mr Davis.
As the government examined the prospect that there could be confusion in the CHO reporting to two ministers in this way?
Attorney?
The CHO provides advice to government in a number of ways. Gives advice to particular ministers in relation to their function during the pandemic. I spoke to the CHO when I was Minister for Agriculture. It's appropriate in his role to provide public health advice to the government, and there's no I can't see how does it matter if he's talking to a variety of members across government. That's appropriate. That's his role.
Mr Davis.
I just want to make a short comment to put on record my concern with this clause. One of the problems through this pandemic, especially the second wave period, is the implementation of the mission coordination committees and approach. Different missions were set up, new lines of authority were set up. The Premier directed that certain secretaries would respond to him and not to their minister. and the confusion and issues that developed from the Mission Coordination Committee approach was a significant part of the failings in that second wave. And whilst the Mission Control Committee was set up at the end of April and went through until late in 2020, it is clear that the breakdown of normal ministerial accountability and normal response of secretaries to ministers, and in this case, the CHO to the health minister, that standard response was modified, and indeed I would put on record that the experimentation that occurred with those mission control committees was a significant cause of the breakdown in good governance and the errors that occurred in the second wave. So I'll just record that this adds to this confusion, and the idea that the CHO should be answering several masters at once, not one primary master, clearly is a particular, or mistress indeed, is particularly a concern.
Attorney?
Let me put it on the record that we have a very straightforward clause here, which is asking that the Chief Health Officer provide advice to the Premier, and that Mr Davis has concerns about the Chief Health Officer of our state providing health advice to the Premier.
Mr Davis.
The Chief Health Officer has always provided advice across a wide range, but there's always been a clear delineation where the primary link was to the Health Minister and the Department.
If there's no further questions on Clause 7, the question is that Clause 7 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Clause 8, Mrs MacArthur.
Thank you, Deputy President. Attorney, Clause 8 relates to the Chief Health Officer's power of delegation. The existing provision in Section 22(1) prevents the Chief Health Officer from delegating this power of delegation, but this proposed amendment makes no such prohibition. Why does the Chief Health Officer need to be able to delegate this power of delegation?
Attorney?
Ms MacArthur, as you can see, the clause confines the ability for the CHO to delegate as appropriate here, as provided by 1A, A and B, but it's not delegating the power of delegation.
Mr Davis.
Can the Chief Health Officer delegate these powers to a non-medical, a person without an MBBS is the best way to describe it.
Attorney?
Mr. Davis, again, for the sake of repeating, I would encourage you to read the explanatory memorandum that is accompanying the bill, because it goes through these issues in quite some detail. These sections relate to authorisation. Unlike the amendment recognises that a large number of authorised officers may need to be authorised to effectively respond to a pandemic, including broader classes of authorised officers permitted to be appointed under Part 13 of the Principal Act. So that if the Chief Health Officer considers it appropriate to delegate his power, that's why the expanded ability to do so to authorised persons has been provided for to assist with efficiently operationalising the pandemic response.
Mr. Davis.
Well, let me record here that whilst I can see circumstances where this could be used appropriately, the Chief Health Officer has traditionally delegated responsibility across across a number of medical areas only to medical practitioners. And this appears to be wide open for the Chief Health Officer to delegate traditional medical decision-making or medical advice to non-medical actors.
Attorney, to take that as a statement? Or?
It's a statement, but it's only for authorising authorised officers to do things as is appropriate. So to suggest that the CHO is going to delegate as appropriate, with respect, Mr. Davis, I think that anybody in the position of the Chief Health Officer is going to ensure that any delegation of their power is delegated to someone who is able to perform the job as delegated.
Dr. Cumming.
Hey. Yes, just thank you, Deputy President, and in the same line of questioning as the opposition leader in this House, under Clause 8, and it talks about Part 13 of the Principal Act currently, and the new section, which is the 165CN, to be inserted by the bill, it actually talks about police officers and expanding the ability to delegate the powers of these authorised persons to assist with the efficient operation of a pandemic response. My concern here is that, as raised earlier, used correctly or wisely, it could be used fine, but what we've actually seen during these times is that this ability or the use of police in a pandemic response has been quite not proportionate in my what I've actually seen so far, as well as I'm still not had any information around if the police actually want to be part of a health response in a pandemic. For myself, police officers really shouldn't be responding to mental health episodes. I don't understand why they've actually been used as part of Mr. Daniel Andrews' army during this pandemic, rather than, as others have said, we should have been using a proportionate health response using medical professionals, not police officers.
Attorney?
Thank you, Dr. Cummings. Police can be authorised but can only exercise limited public health risk powers, not pandemic powers. And just if you follow the clause and how it interacts with the substantive act, it is only limited to the powers that are conferred under sections 165 AW, 189 and 199. And public health risk powers are essentially enforcement powers.
Mrs McArthur.
Thank you, Deputy President. Attorney, please correct me if I'm wrong. Tell me that up till now, the Chief Health Officer has not had the power to authorise police officers, protective service officers, WorkSafe inspectors, public sector employees of other states and territories and designated service providers. Is that correct? Sorry? Oh. The question was, am I correct in understanding that up till now, before this legislation comes into power potentially, the Chief Health Officer hasn't had the power to authorise these extra categories of designated officers? Is that correct?
Attorney?
No, it's covered by Section 250 of the current Act.
So the Chief Health Officer has authorised these people currently?
As authorised officers. Let me look.
So, Attorney, are you responding or is... Yeah,
Like, we went through a lot of this in great detail in the state of emergency extension in relation to authorised officers. And there is certainly and the ability to appoint authorised officers, and also the ability for them. Yeah, look at Section 250. So the Secretary can appoint authorised officers who can exercise powers and enforce public health orders that are issued by the CHO. Existing.
Ms.
The Secretary can authorise authorised officers, but that's different to the Chief Health Officer, isn't it?
Attorney?
So issues the health orders which the authorised officers are enforcing.
Dr Cumming.
Yeah, so just on that, under the state of emergency, that's normally where the police powers would sit. They don't normally, this new section is bringing that ability under the Health Act. So what I understand, it was a separation, like the emergencies sat under the state of emergency. Now you're bringing some of these chief health officers can actually now start directing police. Am I right, Attorney?
Of emergency arrangements by introducing the... Correct. Yeah.
So to be correct here, but it was a separation of these powers. It sat under emergency powers, and now we're bringing these into the Health and Wellbeing Act. Correct. And for myself, and I'll state it again, I'm extremely uncomfortable with this section of this Act, seeing that I believe that when we talk about a health response, I don't believe police officers are the people that should be used in a pandemic or a health response, and I'll keep it at that.
Attorney, did you wish to respond or take that as a comment?
Just ask members to review the ex-mem for Clause 8, which sets out the purpose of this clause.
Thank you. There's no further questions. The question is that Clause 8 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Did you want a division, Dr Cumming? Okay. No? So the clause stands part of the bill. Dr Cumming, I invite you to move your amendment number 5.
Okay, so this is this is a new clause. It actually allows councils to provide vaccinations. Currently, under the Health and Wellbeing Act, it only actually talks about maternal health care, the provision of immunisation to children. In my 20 years plus experience of sitting on a council, there have been many times where councils have provided influenza vaccinations and other different vaccinations to adults. It is a really simple amendment that would actually help in a pandemic situation or any situation. This amendment allows councils to administer flu vaccinations, any vaccinations during a pandemic to children and adults living, working and being educated within that municipality.
Attorney?
Thank you, Dr Cumming. And the government won't be supporting your amendment today, not because we disagree with you, but because it is unnecessary, because there is no, it's not, local governments aren't confined by this Act in relation to what you're seeking to achieve. The section of the Principles Act which requires local governments to administer vaccines to children living or learning in their LGA is set out, but that does not prevent them from administering vaccinations to anyone else, including adults living and working within the LGA. So your amendment's not required to achieve the outcome that you are seeking. We would say that there's nothing in the bill that prevents that from happening now.
Dr Cumming. Davis?
The opposition will support this amendment. We understand what Dr Cumming is trying to achieve. I understand the Minister's point that actually local government is not actually prevented from administering vaccines and immunisations of various types, and do, in fact. But I think if one thing that we can learn out of the pandemic is that local government's role has got to be reinforced, actually got to be strengthened. And this is a good signal, it's a clear signal that this actually that actually sends that signal. I would argue that one of this government's failures is to actually get local immunisation going at an early point in council levels. And we all understand as kids, we got shots at school, we got shots at council chambers, and actually the locality, the proximity was actually a significant part in the success of the rollout of immunisations. And this clause clearly reinforces those important points.
Attorney?
I just wanted to make a comment in relation to Mr Davis's contribution. I concur. We would have loved for local councils to be able to administer vaccination if the federal government would provide adequate supply. Perhaps that might have been something that would have been on the cards at an earlier stage, but to suggest that we haven't been working well with councils is false. The Department for Health works with local governments on a daily basis, and throughout the COVID-19 vaccination rollout, local government have been an essential partner in facilitation of this. We've worked closely with these partners to provide many of the sites around Victoria that have been administering the COVID-19 vaccinations, for example, and many local governments have also been part of the COVID-19 vaccine ambassador program, supporting the rollout of the vaccination through local campaigns. And so councils have done a fantastic job in promoting vaccination.
Sorry, Attorney, I'm going to have to interrupt because it's midnight. I'll call the Minister.
Pursuant to Standing Order 4.08B2, I move that the sitting be extended.
Mr Davis.
The opposition will oppose this extension. We've seen a vacillation by the government as to whether the bill is urgent, whether it's not urgent. It's midnight, it's time for us to go home, and indeed, we think that this is the time to end this for the day and come back on Thursday for a continuation. So we will oppose this attempt to push this late into the night. I should say that routinely government members criticised the opposition when we were in government if we did go late. Well, you weren't here, but no, I'm just making the point. But I'm also making the point that I think it's the staff, is important for the staff, and I think that there's every reason why we should go home now and come back on Thursday to complete this matter.
Sorry, there's actually not supposed to be a debate on this, so we'll put the question. The question is that no, it's not. The question is that the motion as moved by Minister Lean to extend be agreed to. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. I'll ring the bells. The question is that Dr Cummings' amendment number 5 be... Oh, sorry, the question is that the sitting be extended. Those who in favour of extending the sitting, I invite you to stand in your place now. Oh, look at the... Sorry, can we have some quiet, please? Dr Cumming, can we have some quiet in the chamber, please? Order. The clerks have just asked for some quiet so they can think, please. Ms Shing, I've asked twice. Thank you. Thank you. You can resume your seats, and I invite those voting against the motion to stand in their place, and I indicate my voters with the no. Yeah. The results of the division is ayes 22, noes 13. Therefore, the motion is agreed to. And we return to the attorney was speaking on,
local councils, but just confirming that we're not in a position to support Dr Cummings' amendment.
Dr Cumming.
Just on my amendment, and obviously what was raised by the attorney as well as Ms Davis, I believe that this government could have used their arm a lot more, and their arm is local government. I hear the attorney saying that it would have been great if the federal government had handed out the vaccines at an earlier pace, but for myself, watching tents being popped up rather than using council facilities to actually do vaccinations, because the money that was used during this pandemic for popping up tents could have been given to local government to paint their local facilities, to use their local facilities, and you would have had a much more localised response for your vaccination rollout. So for myself, there was a lot of money spent on popping up facilities rather than having localised responses. And yes, you're right, attorney, that when the councils were called upon, they were happy to help, but they weren't called upon enough throughout this pandemic, and the money that this government has used throughout the pandemic could have been used on lasting infrastructure throughout every single municipality for the vaccine rollouts, for testing, and yeah, I feel that this government has squandered money and could have spent money on long-lasting responses and facilities throughout this pandemic. One of the things that upset me the most was when we had testing done, and you'd popped up tents right next to High Point, and then people just walked throughout the shopping centre, potentially with disease. It wasn't well thought out. It could have been used, you could have actually used local facilities, local doctors, and it throughout this whole pandemic. The use of local government was mild. This was actually saying within this, you're actually, for myself, by actually allowing not just vaccinations for children and maternal and childcare nurses, that actually strengthening using local government and vaccines throughout this throughout future pandemics, and using municipalities, it would actually strengthen this whole pandemic management bill, because this is something that was missing throughout the last 18 months, and you need to rectify that for future pandemics.
Sorry, Ms.
Yes, thank you. If I could just briefly speak to this amendment that Dr. Cumming has put forward. And I agree that if we're talking about lessons learned in this pandemic, one of the issues has been the mismanagement of the vaccine rollout. Now, the government will, blame the federal government, and that ping pong will go back and forth. But really, it has been shambolic from the word go. Well, Ms. Symes, the facts are that, if you look at, and I'm not going to labour the point because it's so late at night, but you were offered a booking system by the federal government way back in March, and you didn't take it up, and you went it alone, and there were so many problems with that. That stalled the process. And really, our local government could have been very effective in assisting in getting out into the community, because we know that you weren't even speaking to many parts of the community till very late into the piece. And again, I know that there will be this blame of the federal government, but it's clear that there were significant problems. We know there were significant problems with getting information to the Australian Information Register. It was not put in correctly. There were a lot of issues that were problematic from the state end. You can defend it all you like, but they are the facts. And if we had a better...
The Attorney on a point of order.
Ms Crozier, you have just stated that those are the facts. I can confirm that the facts that you have just outlined are false. The state government was not offered a booking system. They were advised by the federal government that they were developing one, and they never
Attorney,
did.
it's not a point of order. Perhaps you
She's
can
misleading the House.
include that in your answer. Ms Crozier.
Attorney, the federal government was providing a lot of support for you back in March about a booking system that wasn't taken up. Nevertheless, I'm not going to go on with it. What I'm saying is to go to Dr. Cumming's point about using local governments. If lessons are to be learned, and you said, or the Minister did in his second reading speech, that this is why this pandemic bill was come into this House, because of the lessons learned, I think the vaccination rollout in Victoria has been pretty dismal. Pharmacies were slow to get up and running. They were way behind those in other states like New South Wales. There were a lot of issues, and I think if it's done again, if it's to be done again, then using the resources of local government will be much more effective.
That's right. Are there any other speakers? Attorney, did you wish to say anything now? No? If not, the question is that Dr. Cumming's amendment number 5 be agreed to. Those of that opinion say aye. To the contrary, no. I think the noes have it. I'll ring the bells. Haven't we done this one? The question is that Dr Cummings' amendment, which inserts a new clause, or amendment number 5, be agreed to. I invite those who are voting in favour of the amendment to stand in their place now, and I indicate my voters with the ayes. You resume your seats. I invite those voting against the motion to stand in their place. Amendment. You can resume your seats. The result of the division is ayes 15, noes 20. Therefore, the amendment is lost. Are there any questions on clauses 9 to 10 of the bill? If not, the question is that clause 9 and 10 stand part of the bill. Those of that opinion say, oh, hang on. No? There's no amendment to clause 10, no. So are there questions for 9 and 10? Which clause are you asking a question on, Mr Hayes? Okay, so let's just move clause 9 first. If there's no questions on clause 9, the question is that clause 9 stand part of the bill. Those of that opinion say aye. To the contrary, no. I think the ayes have it. All right, I'll ring the bells. question is that clause 10 stand part of the bill, was it? No, clause 9, was it? Sorry. Clause 9 stand part of the bill. I invite those voting in favour of the clause to stand in your place now. Sorry, you can resume your seats, and I invite those voting against the clause to stand in their place now and indicate that my vote is with the no. Thank you. You can resume your seats. The results of the division is ayes 19, noes 15. Therefore, the clause stands part of the bill. Are there any questions on clause 10? If not, the question is that clause 10 stand part of the bill. Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Attorney, I invite you to move your amendment number 5.
Thank you very much, Deputy President. And look, this is a substantial amendment. It responds to concerns that have been raised. It indeed seeks to clarify some matters, but I guess best description would be to ensure that we are cementing independence in the detention review scheme. The detention review scheme was established in April of this year and acts as a significant additional safeguard concerning detention decisions. There's a lot of debate around detention, and as the bill provides, detention is more often than not, in the practice that we've come to know throughout the pandemic, is the requirement to isolate, whether you are a arriving traveller or indeed you are a positive case, close contact, and required to self-isolate at home. That is the practical application of when we are talking about detention in the vast majority of situations. The Public Health and Wellbeing Act currently allows the Secretary to appoint detention review officers who are employed under the Public Administration Act, who must be lawyers with at least 10 years' experience. New section 165BJ provides that upon review of a person's detention, they are empowered not to vary the person's detention or refer the application to the CHO for review. As I said, there has been issues raised. I've had a lot of questions from human rights advocates and also legal stakeholders. Consistent concern has been raised that the detention review scheme, whether in reality or whether it's perception, lacks sufficient independence. Competing tensions arise between strengthening the independence of a detention review and not compromising the efficiency, timelines and public health focus of the current process. So on balance, the following amendments have been proposed, taking into account the key drivers of public health considerations, as well as having a system that actually in practice works. First, the detention review officers will be renamed detention appeals officers and be appointed by the Governor in Council rather than the Secretary. They will no longer be employed under the Public Health Administration Act. Second, to further underscore their independence, it's proposed that the bill expressly provide that the detention appeals officers are not subject to the direction of the Secretary or the Minister in respect of any decision made. And third, instead of the Chief Health Officer, detention appeals officers will be empowered to vary, cease or affirm a person's detention. So, in other words, they will be the final decision maker. They'll be required to make a determination and, using best endeavours, provide written reasons within 72 hours of an application being received. Their review of an application will be de novo, encompassing any matter considered relevant. To ensure that public health expertise remains central to decision-making, detention appeals officers will be required to consult with the Chief Health Officer before deciding to cease or vary a person's detention. And finally, a number of amendments that are consequential are directed towards ensuring that the detention appeals officers are supported in their independent role, including requiring the Secretary to appoint a registrar who will support the detention appeals officers to make contact with the applicant and use best endeavours to provide the detention appeals officers with the information required to make their decision. So not decision making, it's just administrative support. Importantly, these proposed amendments, as I said, strike the right balance between providing an independent review of a person's detention, ensuring that the process remains timely and informed by the most up-to-date public health expertise. And Deputy President, in practice, we will commit to ensuring that the public health orders, the detention orders that are provided to any individual that is required to isolate, for instance, would have very clearly set out the location, the time and how to access the review, and indeed how to make a complaint to the Ombudsman.
Mr Hayes.
Thank you, Madam Deputy President. And Minister, I just wanted to ask, I've got two questions. Firstly, I just want to say this is a vast improvement on what was in the existing legislation. It does really bring some independence into it in the way of the review, and I commend the changes, and something that I was pleased to see. But I want to put it on record that I was pressing for the ability to have as an add-on or either appeal to a magistrate if the person detained so wanted to go there, because I believe that preserves the intention of habeas corpus when someone is detained against their will, that they could go to a court. And I know that they can go to the Supreme Court, but that's a bit of a high bar for the ordinary punter to try and get there. So I just wanted to, for the record, if the attorney would state why the government wasn't inclined to go down that path for us first, and then I have one more question after that, if I could.
Attorney?
Deputy President, and thank you, Mr Hayes. I know that we've had extensive discussions about this particular matter, and as you know, both myself and both Professor Pfizer spent a lot of time mulling over the merits of being able to appeal to VCAT or the Magistrates Court, but for the reasons as I outlined, to ensure that a review is meaningful, to ensure that somebody has the ability to have that dealt with before, frankly, they've finished the term of their detention, was a key decision or a key factor in making or landing where we did. I consulted extensively on this. I spoke to VCAT, spoke to the Magistrates Court, spoke to the LIB, and certainly spoke to the Ombudsman, and can confirm that stakeholders are comfortable with the new arrangements as proposed by the amendments today, the appointment of the VCAT magistrates and judges is also a GIC appointment, which is what is proposed to be the vehicle to appoint detention appeals officers. So to absolutely enshrine their independence and to confirm to you, Mr Hayes, that the appointment process is akin to those other judicial or tribunal memberships. So as I said, the provision of information for people to access review will be clearly set out. And also the Ombudsman was very keen to ensure that people who might be subject to a detention order were afforded the ability to contact her and make a complaint if they so thought that was so wanted to access that. As I indicated in putting my amendment, the detention review scheme has existed since April under the current regime, and I can report that there has been a number of reviews sought, 266, and in terms of the process that's been followed, we haven't received any complaints about people that have accessed that detention review scheme. However, as indicated, what we really wanted to do was ensure that there was public confidence in, and particularly stakeholders who raised concerns about ensuring that the system was robust and completely independent. And I can confirm that there is no ability for the Minister or the CHO or the Secretary or anyone else within government to provide a direction to an officer when they are exercising their review of an application.
Mr Hayes.
Thanks, Deputy President. Thank you, Minister. It is a great improvement. I also wanted to ask here about 32E in your amendments. Detention review officers are taken to be detention appeal officers. So that's the existing review officers will become detention appeal officers, but the raising of the bar, the criteria is now an Australian lawyer of 10 years experience. So if the existing detention appeal, the existing detention review officers, sorry, I'm going into outer space too. So if the existing review officers are not lawyers of 10 years experience, will they still be rolled over into the new category?
All of the existing officers fit that criteria, so they will be transferred to the new system. They all qualify.
Deputy President, Minister, can you outline how many detention review officers are currently appointed under the current scheme, just so we've got an idea of the scope of that?
We will have that because I asked for that a second ago. 8.
Thank you, Deputy President. Thank you, Minister. So those 8 dealt with the 266 appeals you referred to earlier. Can I ask you about 32C, which is the terms and conditions of appointment for the new proposed detention appeals officers? Can you clarify 32(1)A, which is the period of appointment? 32(1)A states, detention appeals officer holds office for the period specified in the instrument of appointment, which must not end after the time when the pandemic declaration or declaration of state of emergency referred to in section 32A1 ceases to be in force. Somewhat clumsily worded, but is the intent there that the appointment of a detention appeals officer does not extend beyond the declaration of the pandemic?
Attorney?
Correct.
Thank you, Deputy President. Thank you, Minister. Given that, Minister, can I take you, and we'll come to this later, but clause 12, which provides that the new 165AB, the Premier may make a pandemic declaration, and it goes on to talk about the form of that. But it states in 165AC that a pandemic declaration must be in writing and must specify the period, but the period for which a declaration continues in force must not exceed a period of 4 weeks, and then it can be extended. So a declaration can't be made for more than 4 weeks. Does that therefore mean that the appointment of a detention appeals officer can also not be for more than 4 weeks at a time?
No, but let me find out. Rich Phillips, the appointment of a detention officer, a detention appeals officer, is contingent upon the existence of a pandemic declaration, and therefore, even if they were, the role would not exist. There would be no role to play without a pandemic declaration in place. So, in the unlikely event that there was a detention order in place at the same time as a revocation of the pandemic declaration, it would cease.
Thank you, Minister. That's not the issue I'm going to, though. The issue I'm seeking clarity on is the period of appointment for the appeals officer, because you've clarified the appeals officer's appointment cannot go longer than a pandemic declaration. And the Act is quite clear that a pandemic declaration can only be for 4 weeks, and then has to be a new pandemic declaration. Therefore, it follows from that the appointment of a detention appeals officer can also only be for 4 weeks, being the maximum duration of a pandemic declaration. Then a new pandemic declaration would have to be made, and presumably a new appointment for the appeals officer also made. Is that correct?
The declaration still exists, it's just extended. It's not until it's revoked that you would find a situation where the term of a officer would cease.
Thank you, Deputy President. Thank you, Minister. Could you expand on that, Minister, to the extent that I take your point about declaration exists, but the Act, or the Bill rather, is quite clear, and it says in relation to a pandemic declaration, declaration must be in writing, must specify the following: the period for which the declaration continues in force, which must not exceed a period of 4 weeks, but may be extended under section 165AE. So it's saying it must not exceed a period of 4 weeks, and then you can have a new one. Does that not automatically follow then that the appointment of an officer would also expire at 4 weeks, because it must end when the declaration ceases? So would we? I'm just.
No, because the time period can be extended, so there's no. The declaration doesn't come to an end. Unless it's revoked, it's just extended. So there's no severing of the declaration arrangements. There has to be a positive action. Either has to be extended or revoked.
Thank you, Deputy President. Thank you, Minister. So is this, in that sense, is this provision different to what we currently have with a state of emergency? Because with the current state of emergency, that has to be renewed on a monthly basis, and all the orders which have been made by the CHO under the existing state of emergency expire with the state of emergency and are then remade with the new state of emergency. None of those purport to continue through the creation of a new state of emergency. They have intentionally all lapsed. The end time for those have all been set with the end of the state of emergency, and fresh orders have been made replicating the originals with the new state of emergency, which makes a very clear distinction between a state of emergency ending and the new one beginning. Are you indicating that this provision around pandemic declarations is not the same? So it is not one ending and a new one beginning for the purposes of these appointments, but also, frankly, the orders that will be made under these?
Mr Rich Phillips, page 11 of the bill goes through the fact that the declaration continues to be enforced for the period of the declaration. So pandemic orders don't have to be remade under an extended declaration, but usually have an end date and would be remade.
Mr Rich Phillips.
Thank you, Deputy President. Thank you, Minister. What period of time have the existing detention review officers been appointed for?
Attorney.
In terms of every individual one of the 8, I don't know when they all started, but they were appointed in April.
Rich Phillips.
Thank you, Deputy President. Are you aware, is it a 6-month appointment, a 12-month appointment? What was the basis of the appointment, and what would be the government's intention with the new detention appeals officers?
1 year.
Mr Rich Phillips.
Thank you, Deputy President. Thank you, Minister. The reason I ask about the appointment period of the detention appeals officers is it goes to the question of independence. You spoke, Dr Bark earlier asked you, I think you referred to some concerns raised by the Bar Association with respect to the Minister making appointments under this provision. You indicated that in your view it wasn't a concern. You appoint judges, you said you appoint Supreme Court judges, magistrates, etc., which is of course correct. However, you do not reappoint those people. Once you have appointed them, they hold office until they reach retirement age. And the capacity to remove those people judges is extremely limited. These officers, you've indicated, are only going to be appointed for 12 months. And then a new GIC appointment would be made, assuming an ongoing pandemic.
Just in terms of responding to that, I would say that most of the advocacy suggested that VCAT be the correct or the preferred jurisdiction for reviews, for appeals of detention orders be made, and VCAT members don't have tenure, and in that sense their appointments are identical to the appointments that we are making in relation to DROs. So I guess on the flip side is we don't want to appoint detention review officers for life because we don't want pandemic to be here for life.
Rich Phillips.
Deputy President, thank you, Minister. I take the point that you don't want to appoint them for life, but equally their period of tenure will go to their perceived or actual independence. And while you can put a paragraph in the bill saying they're independent, the reality is if they're relying on reappointment every 12 months, they may not be as independent as the government suggests. With VCAT members, they obviously deal, if VCAT was the appeal body, they would be dealing with a broader suite of matters than simply the discrete issues of review officers, detention review officers. They're part of the tribunal, the bigger organisation. If the government decided to not reappoint VCAT members because they didn't like the way they had operated as detention appeals officers, that would be quite visible. With these officers, a discrete appointment, one purpose, not part of a bigger tribunal, the ability for the government to not reappoint officers because they didn't like the way they had operated, the way they had made decisions in the previous 12 months, certainly has the potential to undermine their independent actions as officers, given they need to rely on reappointment if it's ongoing every 12 months.
Attorney?
I'd probably draw the House's attention to the reality, the experience that has been for the past since April, since we've had the detention review officers, the experience of people that have undergone the system who have sought to seek a review, we don't have a myriad of complaints. We don't have a concern from people that the current DROs aren't acting independently. That's not an issue that's being raised. It's more about the fact that because they're appointed by the Secretary, there was the perception that they could be. So this is fixing a problem that doesn't exist, Mr. Rich Phillips. However, we did, after intensive negotiations with Mr. Barton and Mr. Hayes, who, in conjunction with some stakeholders, were very keen to see the independence enshrined, the independence enhanced, and this is a model that has been endorsed by the Ombudsman, who is indeed very focused on the independence and oversight of these matters. Detention is something that, whether it's isolation, lockdowns, or indeed youth justice and the prison system, the Ombudsman has shown a keen interest in the rights of people that are subject to detention or subject to having their liberty constrained, and so I would respectfully suggest that this model is the right model, and the independence is being supported by what we are proposing today, notwithstanding that we can't guarantee an appointment for life for a detention appeals officer.
Minister, is it the government's intention to roll over the appointments of the existing detention review officers to become detention appeals